but we also see who commissioned you on the 5th. Just explain why it is that that TM and that commission signature appear on this document.
It's simply because this document is the same document that we discussed earlier. The commissioner never signed anything further than he signed on the document submitted to this committee on the 25th.
Right. So is it your evidence that this is a copy of the 25th of February affidavit?
Yes, ma'am.
Let's go down to the next initials at the top of the next page, 487, is it? Yes. Again, TM, that's you, correct?
Yes, ma'am.
And you signed there because you've made a handwritten change, correct? In that paragraph.
Yes, ma'am.
Right. Move on. Again, 7.3.
Yes, ma'am.
And again, the reasons are the same. You signed and you alone signed because
Yes.
of the change that's in 7.3.
That's correct, ma'am.
Explain again, Advocate Madonsela, and please be patient here. We really want to rule out any confusion that may still remain. Why does TM and the commissioner's affidavit, again, commissioner's signature again appear here, adjacent to 7.4 and 7.5?
Because again, the commissioner's signature and my original signature are the same signatures that were in the document of the 25th. Nothing changed. It's the same document. And the only change is in 7.3, where I indicate the corrections made.
Right. Seppo, follow the initials again. I'm gonna go. Again, 8.3, you have a TM there because you've made a change, correct? A handwritten change.
Yes, ma'am.
The TM and the commissioner's affidavit, is your evidence the same as to the reasons why that appears there?
It appears there because it was always there from the 25th. Yes.
Right. Sepoko. Next one. Just go up. Yeah. There's another TM next to 9.6. There appears to be a handwritten change there. That again is you, correct?
Yes, ma'am.
Right. Go down, Seppo. And that's your signature and a TM because you corrected your name, right?
Yes, ma'am.
And we of course see that this is the same statement of the 25th of February that was signed in Stellenbosch that we spoke about earlier, right?
Yes, ma'am. I affirm that nothing changed insofar as the original signatures were concerned.
So, Advocate Madonsela, is it correct then to say that the change is made on the 25th, on the copy of the 25th of February affidavit was signed or initialed not just by you, but by both you and the commissioner? Is that correct?
No, ma'am, it is not correct. It's not true.
Your evidence is that those changes, those handwritten changes on that copy were signed by you and you alone, right?
Yes, ma'am. That's why I wanted a withdrawal of the attack on the colleague who was Commissioner of Oaths, because there was an insinuation that he's a criminal.
Right. Now let's deal with your affidavit of the 28th of February 2023, page 482, Tsapo. So Advocate Mbofu suggested that this affidavit was flawed or defective in some way because it wasn't initialed by the commissioner on every page. Do you remember that?
Yes, ma'am.
So when he was asked to refer the committee to the law that makes this a requirement, he referred the committee to section or to regulation 4 subsection 1, of the regulations governing the administration of oaths or affirmation. Tsepo, put that up, please. Yes, that's the one. Let's go to the section that Advocate Mpofu referred to the committee to. You referred the committee to Regulation 4, subsection 1. Can you indulge me, please, Advocate Madonsela, and read Regulation 4, subsection 1 into the record?
Chair.
Thank you, ma'am.
Just before you do that,
below-
my apology, Advocate Madonsela, just before you do that, I have a hand.
No, thank you,
Advocate
Chair.
Mpofu.
No, I wanted to know if this witness is also being called as an expert in law. If she is, then she should be qualified so that we can then deal with her as such.
Thank you. The witness is being asked to read the document. Advocate Mayosi.
Yes.
No, Chairperson. Sorry, Chair.
I'm with Advocate Mayosi now. If you're raising
but
a
he was
hand, I'll come
speaking,
back to you. If you raise a hand, I'll come back to you.
Yeah,
Yeah, you've got to allow the flow of the meeting so that it's not you who must be listened to.
no,
Thank you.
Chair.
I'll come back to you. Advocate Mayosi.
Chair,
Chairperson, I'm objecting, yeah.
Advocate Mayosi.
Chair, the witness is being asked to read this section into the record. This is in direct response to Advocate Mpofu having brought this very section of the regulations to the attention of this committee and having relied upon it when he was asked specifically to show the committee what he was relying on.
Thank you. Advocate Mpofu.
Thank you, Chair. Yeah, no, that obviously is so. That's not the point I'm making. I think she's missing the point. The point I'm making is, you'll remember, Chair, that after lunch, I came back after I had been asked, I think by two members and Advocate Mayosi, and I told them that I don't keep every section in my head. And I addressed you on the sections for you to note. That's it. I never addressed that to the witness or through the witness, because if I wanted to deal with the witness as a legal expert, then I could have canvassed it through the witness, which is what she's doing. That's exactly the point I was making. Legal argument will be made when the time comes for legal argument. But and there's nothing wrong if the witness is an expert in interpretation of statutes, in putting it. I'm simply saying that then she must be qualified as such so that we deal with her as an expert in the interpretation of statutes.
Thank you, Advocate Mpofu. I'm still not connecting with the expert argument. Advocate Mayosi, then I go to Advocate Madonsela.
Thank you, Chair. Also, I'm not asking the witness to interpret anything, but thank you, Chair. I'll proceed.
Just before you proceed, then, Advocate Madonsela.
Thank you, Chair. Well, I thought this was my opportunity to
flag the
read
document, Tsepo.
the document.
Yes. It's Regulation 4, subsection 1. Please, Advocate Madonsela.
Thank you. Regulation 4, subsection 1 says, below the deponent's signature or mark, the Commissioner of Oaths shall certify that the deponent has acknowledged that he knows and understands the contents of the declaration and shall state the manner, place, and date of taking the declaration.
Thank you. Thank you, Advocate Madonsela. Tsepo, now take us to the affidavit of the 28th of February to test that affidavit against what section 4, subsection 1 says. Go to the end, page 485. Now, what you've just read of Regulation 4, subsection 1 is that what the Commissioner of Oaths must do is that he shall certify that the deponent, being you in this case of this affidavit, has acknowledged that she knows and understands the contents of the declaration, and that she shall state, the Commissioner that is, the manner, place, and date of taking the declaration. Has this been done by the Commissioner in relation to this affidavit? Advocate Madonsela?
Yes, ma'am.
Let's go back to the regulation, Seppo. I'd like us not to just look at regulation for subsection 1. Can you also just read regulation for subsection 2 into the record, because it talks specifically to what a commissioner of oaths shall do in signing a declaration. Can you read those for us, please, Advocate Madonsela?
Thank you, Advocate. Subsection 2 says, the Commissioner of Oaths shall sign the declaration and print his full name and business address below his signature, and B, state his designation and the area for which he holds his appointment or the office held by him if he holds his appointment ex officio.
Thank you. Go back to the affidavit of the 28th of February, Seppo, page 485. And my question again to you, Advocate Madonsela, has the commissioner done what is required of him in terms of regulation for subsection 2?
Yes, ma'am, he did exactly that. As you can see, the stamp and also affirmation of his presence.
Right. In your evidence yesterday on this issue, you made mention of a case in the Western Cape High Court. You mentioned it during your evidence, but you couldn't elaborate on it. That is the case of Minister of Safety and Security and others versus Mohammed, right?
Yes, ma'am.
Share the citation for this case for the assistance of the committee is square brackets 2010 for all SA 538 brackets WCC, Western Cape High Court, a judgment that was delivered on the 30th of April 2010. Can you tell the committee, Mr. Advocate Madonsela, please, what the relevance of that case is to the issues raised by Advocate Mpofu in relation to your 28 February 2023 affidavit?
I think the essence of the Mohammed case is simply that an affidavit or a document so signed is not invalidated simply because the signature or not the signature, the initials of the Commissioner of Oaths are not on every page.
Thanks. I've taken the liberty of making a copy of the case. Seppo, can you put it up, please? Yes. That's paragraph 26 of the case. And as Advocate Madonsela has alluded to, the issue that this paragraph was dealing with was the legal status of an affidavit where that affidavit does not contain the initials of the Commissioner of Oaths and on every page. And there I'm reading the bold and underlined, although it certainly is the practice for both the deponent and the commissioner to initial all pages of an affidavit on which their signatures do not appear, this practice is not a requirement for the validity of the affidavit. It is not required by the rules governing the administering of oaths and affirmations that are set out in the regulations promulgated under Section 10 of the Justices of the Peace and Commissioners of Oath Act 16 of 1963. Is that what you were referring to, Advocate Madonsela?
Certainly, and thank you for the opportunity to present it properly.
Now, the section, regulation 4 subsection 1 that was relied upon by Advocate Mpofu, does it say that a commissioner is required to sign, to initial every page of an affidavit that is presented to him?
No, ma'am, we just read it. It definitely does not say so.
Thank you. So just to move quickly along to the second issue that I said I was going to deal with today in my interaction with you, and that's the issue of the motion. So let's turn to the motion. Seppo, put it up, please. And I just want to point out two things at the outset, Advocate Madonsela, relating to the motion. Just for you to get a sense of the approach that the evidence leaders will follow relating to you and the motion, and the reasons for that approach. So two things. The first one is that engaging in it is the understanding of the evidence leaders that engaging in a competitive exercise between Advocate Mkhwebane's conduct and that of her predecessors, including yourself, doesn't form part of the mandate of this committee. So my interaction with you is not going to involve that. Do you understand that, Advocate Madonsela?
Thank you, ma'am. That was what I had been assured of.
Yes, the second point I'd just like to point out up front is that there's already evidence before this inquiry on the aspects of the motion that mention you in relation in particular to CIX and Vrede. So the fact that there's already evidence, coupled with the length of time that has passed, coupled also with the fact that you told the evidence leaders that you no longer have access to records. These issues are the reasons why the evidence leaders determined that it wasn't necessary to call you for oral evidence. And the contents of the statement that you recently filed didn't change that determination on the part of the evidence leaders. Are you with me, Advocate Madonsela?
Certainly, ma'am, I am. Thank you.
Yeah, but you're here now, Advocate Madonsela, and we're grateful for that. But for all these reasons that I've just asked to put up front, I'm going to be very brief with you when it comes to the motion. Are you with me again?
Yes, ma'am.
Yeah, so let's turn to the motion. Starting with charge 1, which is where Advocate Mkhwebane is alleged to have committed misconduct in relation to various things which it is said she did or failed to do in connection with the investigation, report, and litigation in the sub-CIX matter. You see that?
Yes, ma'am.
So go down to paragraphs 1.1 and 1.1.1. Yeah, 1.1.2 and 1.1.3, starting with 1.1.2. There, it is said that Advocate Mkhwebane, amongst other things, his conduct was objectionable because she materially broadened the scope of the investigation in the final report as compared to the provisional report, without giving notice thereof to any affected person and without furnishing any explanation. Therefore, do you see that?
Yes, ma'am.
And it is also said in the next paragraph, 1.1.3, that she materially altered the remedial action in the final report as compared to the provisional report on the instruction and or advice of the presidency and or the state security agency, and without giving notice and an opportunity to comment thereon to affected persons. You see that?
Yes, ma'am.
Now, the evidence that is already before this inquiry, and which you've now also confirmed in your affidavit, and I think this is fairly uncontentious, is that you left no approved or signed off provisional report when you left the PPSA in October 2016, right?
Yes, ma'am. And
the final report in this matter was issued on the 19th of June 2017, more than 18 months after the end of your term, right?
Yes, ma'am.
So the comparisons between the provisional and final reports that are referred to in these paragraphs, in these charges, these would be comparisons of provisional and final reports issued by Advocate Mkhwebane and not you, correct?
Yes, ma'am.
Chair. Okay. Firstly,
Yes, Advocate Mbofu.
apart from the futile attempt to amend the charges, that cannot be put as a leading question, because once again, it's evidence from Advocate Mayosi, which is completely worthless unless if it's given under oath.
Thank you. Advocate Mayosi.
And subjected to cross-examination.
It's on the record, Chair. You can ask the questions differently. It is your evidence that you didn't issue a final report, correct?
Yes, ma'am, and I said so yesterday as well. It's just a confirmation.
And it's common cause on the record that Advocate Mkhwebane issued the final report in June 2017, correct?
Yes, ma'am.
You didn't issue a provisional report, as you stated in your evidence, and it's on the record that a provisional report was issued on the 20th of December 2016 by Advocate Mkhwebane, correct?
Yes, ma'am.
Thank you. So the comparisons are not in relation to reports issued by you, correct? It follows.
Yes, ma'am.
Thank you. Can we move?
Chairperson,
Just pause, Advocate Mayosi. Advocate Mbofu.
yeah, surely Advocate Mayosi must know that she can't do what she's doing. Surely. If you know,
What am I doing?
Sorry, yeah.
you can't
Before
put
you
a
come in.
conclusion to a witness, a legal conclusion that you seek to draw. You can argue it at the end. You can't put it to a witness. What's the witness supposed to say? Just a prop. This is not generations. So she must just say yes, yes, and to your evidence.
Chair, no legal conclusions were drawn here. These are factual conclusions based on the common cause evidence and based on the witness's confirmed evidence. Let's move on to the Friede dairy matter. Sepo, please put it up. It's the motion. It's the motion. And again, this is a charge of misconduct in which Ms. Mkhwebane is again alleged to have committed, to have done various things or to have failed doing various things in relation to the investigation, the report that was issued, and also the litigation, the ultimate or subsequent litigation in the Friede dairy matter. Are you generally familiar with this charge, Advocate Madonsela?
Yes, ma'am.
It then proceeds to have subparagraphs which, as do all the other charges in the motion, which describe what it is said Advocate Mkhwebane did or did not do in relation to the Friede matter. In paragraph 4.4, it is said that Advocate Mkhwebane materially altered the remedial action proposed in the provisional report prepared by you before issuing the final report without providing any rational or proper explanation therefore. Do you see that?
Yes, ma'am.
Now, you testified yesterday that you didn't leave a provisional report in this matter, correct?
Yes, ma'am.
Is it also your evidence that you didn't leave a final report either in this matter?
Yes, ma'am, it is.
Sepa, please go to bundle A, page 1273. Bundle A, you've got it? Let's go down slowly. Go up. Yes, that's fine. Advocate Madonsela, this document, which is on the record, is a provision, says it is a provisional report on the investigation into complaints of maladministration against the Free State Department of Agriculture in respect of non-adherence to Treasury prescripts and lack of financial control in the administration of the Free Dairy Project. So in short, it suggests that it's a provisional report in relation to the Free Dairy Project. Do you see that?
Yes, ma'am.
Go down, Sepo. Stop. So there at the top, there's a line that reads invisible oversight, provisional report by the public protector dated November 2014. Do you see that?
Yes, ma'am.
You were still the public protector in November 2014, correct?
Yes, I was.
Go to page 1351, Tsepo. The last page. Yeah, go down. Yeah. Do you see that this document obviously has your name in it as the public protector, and this, I think this is also part of the evidence before the committee. Advocate Cilias was part of this investigation. Do you see that?
Yes, ma'am.
It's an unsigned document. Are you able to tell the committee at all what the status of this unsigned provisional report is?
It was not a provisional report in the status of a provisional report of the Public Protector. In other words, it had neither been quality assured by the quality assurance team, nor signed by me. When you see those initials appearing, all draft documents of the Public Protector have that, although we had advised team members to stamp draft on documents, but it was a new practice. So you'll find every draft report, no matter how rudimentary it is, it would have the initials of the Public Protector and the investigators that are working on it.
Was this, I mean, you've testified that you never left a provisional report by the time your tenure ended. It's correct, is it, that you never signed off on this report?
Certainly. And my evidence yesterday, you will recall, if you may, ma'am, was that I then asked Mr. Samuel to take over this investigation. And he certainly went there after these elevations had been prepared.
So yesterday, Advocate Mpofu, I think in relation to this issue, asked you a question to the effect that it would be illogical to then conclude that you had left a provisional report behind, to which you said that it would be untrue that this was so. Is that your evidence?
It still is, ma'am.
It would not be true, I think you said. You struggled with his use of the term illogical. You preferred it would not be true. Is that right?
I did, ma'am, because it depends on the context. If the facts appear to logically connect, you would arrive at a particular answer. It's not illogical on what appears to be facts. And then, of course, if later you realize that what appeared to be facts are not facts, then it just becomes untrue.
So if a representation or a statement is made in an affidavit or anywhere to the effect that this November 2014 report was a provisional report issued by you, would that be false or would that be true?
That would be definitely false. A provisional report is a signed document by the public protector.
Okay. I don't have any further questions for Advocate Madonsela, Chair. Thank you, Advocate Madonsela.
Thank you, ma'am.
Thank you, Advocate Mayosi. You would have started at just 9:15, and you're done now on your part. Thank you. It will now be an opportunity to turn to members, for members to interact with the witness. If they have any questions they want to raise with the witness. So I'm now going to open for that opportunity, and I will start inviting and noting members that wish to do so. I start with Honorable Milam as the first member. Followed by Honorable Begizwe Ngosi. Are there any other members on the virtual platform that wish to interact or ask questions with Honorable Madonsela? Because I seem to have been done here. Okay. Honorable Zungula, you will be next. And those will be the last hands on the virtual platform. Let's start in that way. Honorable Milam.
Thank you, Chairperson, and good morning to everybody. Advocate Madonsela, good morning to you.
Good morning, sir.
Advocate, could you tell me, you indicated yesterday that some of your reports were taken on review. Is that correct? Did I understand you correctly?
It is correct, Honorable Myla.
Now,
although I was never involved in that process.
can I ask, you said that you were disappointed by the outcomes, but what did you do when those reports were taken on review? What action did you take?
Well, on the one case that was taken on review when I was still public protector, it might be 2 or so. When they were taken on review, we defended the case, and when we lost, we reflected on the outcome. For example, in the SABC manner, we reflected on the outcome and we decided to take it further to the SCA.
Okay. And when it went to the SCA, what was the outcome there?
At the SCA, we won the case. And that's why we got the precedent from the SABC manner, from the SABC case that said the public protector's decision has legal force. Of course, it didn't specifically say at that stage it had a binding effect, but it meant the same thing. We did the same with the Nkandla judgment, and with the Nkandla judgment, it was decided in our favor upfront.
Now, let me ask you this. You alluded to it, but let me ask you straight up. In any of those reviews or any matters while you were the public protector, were you found by a court to be ignorant of the law?
Not to my knowledge, sir.
Were you found to have misled the court or in any way submitted false information or infactual or unfactual, I'm not sure what the correct word is, information?
Definitely no on that one. Again, not to my knowledge.
And were your investigation processes at any point questioned by the court?
Not to my knowledge, sir, although there is a case that was brought in yesterday by Advocate Mpofu, where a judge in the High Court questioned my reasoning.
Okay, so questioning your reasoning versus questioning your processes, that's a different ball game, isn't it?
To my understanding, it is, sir.
Thank you, Chairperson. I have nothing further.
Thank you, Honorable Mailam, for those questions. I now turn to Honorable Becky Zwengos.
Good morning, Chair, and good morning to Advocate Madonsela.
Good morning, Honorable Nkosi. Good morning, sir.
In your tenure as the public protector of the Republic, did you apply the provisions of the Constitution and the law applicable to your office and other related law in respect of cases that you receive?
I did so, to the best of my knowledge and ability, sir.
In doing so, do you think that you applied your knowledge and your experience in the execution of your responsibilities?
I did so. Say that would be my understanding, sir.
Would you say that the application of the law constitutes your strength? And are there any weaknesses in that regard?
Will you repeat the question, sir?
Would you say the application of the law, based on your experience, constitutes your strength?
I would say it is my greatest strength, and that was complemented by the Bar Council, the Law Society, and the Deputy Judge President of the High Court of the Gauteng, Northern Gauteng High Court, when I was awarded the Truth and Justice Award by the Law Society. And that is just generally what I was praised for, because, and I do know that that is my strength, because I don't just take advice from my team. We debated sometimes until the early hours of the morning. I also would not take advice from counsel. I would indicate to counsel what I think should be the approach. And then we would obviously then deliberate accordingly.
Okay, thank you. On your leadership, when you joined the PPSA, would you say that you moved the institution from what it was to a greater level or to a higher level?
My view is that I did, but I didn't do it alone. Firstly, as I said, say, in my affidavit, I inherited an institution that was rooted on grounding. I know the media often says differently, but every time the media says that, I say that if there were no fundamentals that had been built by my two predecessors, I would have not been able to take the institution to the next level. So it was a process of building on the shoulders of giants and working with a marvelous team to learn and grow together.
Would you say that the standard operation procedures that you introduced enhance the work of the public protector? As an
Certainly.
office?
Yes, sir. This has been even recognized by Yale University. If you Google this, there is a whole podcast and transcript where Yale University tried to document what we did during my time, which was to build on the systems that my predecessors started, both at the level of general administration, but more so on case management, from triaging to report writing and managing stakeholders and the media. And to top it, then I did prepare that standard operating protocol, which was quality assured with the team, think tanked with the team before I signed off.
Did this assist in proper case management of the complaints, and was it effective?
The case management and complaints was incrementally better. I would say it became a poly exercise. As a mountain climber, I would use that exercise, that it was not.
Sorry, it became what exercise? Advocate Madonsela?
Poly, that's it. Oh, sorry, say it's a Tanzanian.
Oh, okay. We're not
about climbing a mountain one step at a time. I don't say that we summited the highest peak, but I can confirm without any fear of contradiction that we summited quite a number of peaks on the way towards the highest peak.
Would you say that in executing your responsibilities, you did so without fear or favor to any person, be it a baking kosi or a Koko Dlamini or Mkhulu Gunene?
Absolutely, sir. As a result, there were times when we stood alone as a team, but we stood together, which was great.
Okay, my last question. When you left the institution, did you leave an institution that Begging Kosi would be able to inherit and run with? And would you be proud of an institution that you left?
Absolutely, sir. I would say that I left an institution that would make my successor have it easier than I did. But I also want to say that my predecessors made it easier for me than it was for them. And we had systems for case management. It was just the electronic version that we had to impair, because it was not of the capacity that could contain the caseload that we had started to inherit after the Scorpions were impaired. I also left policies that dealt with matters such as procurement, etc. But also, in addition to the institution, I personally conducted training together with other team members. We regularly conducted training on investigations, particularly to empower provinces, because before my time, they didn't do complex investigations. They only did inquiries.
Thanks, Chairperson.
Thank you, Honorable Ngosi. I now recognize Honorable Zungula.
Thank you, Chair. Greetings to yourself, members of the committee. Morning, Ms. Madonsela.
Greetings, Honorable Zungula.
I think let me start with the CX report. Would you agree that one of the contributing factors in the lack of appetite to recover the money by government was an attempt to protect the economy in line with the mandate of Treasury and the Reserve Bank?
Certainly, sir, I would agree that the argument had been that if we did collect the money, there would be a run on the bank. From a run on the bank, there would be a run on the rand, and a run on the country would be a run on the economy. And therefore, not that the money shouldn't be collected, but the feeling was that given the fact that it was different shareholders that had invested in the bank at that time, and we were now trying to collect years later, when new shareholders would now have to pay for it from that bank. And the bank concerned had even been bought by an international bank.
Okay, so in that sense, money that belongs to Gogo Dlamini would not be recovered because of that particular mandate. Now, would you say it's unreasonable for the mandate to be reviewed to protect Gogo Dlamini?
I would say it's unreasonable to review the mandate. Will you please repeat that question, sir? I did not quite understand.
So I'm saying that in line with your answer now, which effectively means that money belonging to Gogo Dlamini cannot be recovered from ABSA because of the mandate. Now, would it be unfair or unreasonable to review the mandate to make sure that Gogo Dlamini is protected?
So whose mandate?
The mandate of the
Would be
Reserve
reviewed
Bank.
here. You mean the lending mandate of the bank?
No. In my first question, I said one of the contributing factors in the lack of appetite was the mandate was to protect the economy in line with the mandate of Treasury and the Reserve Bank. And you said you agree with that, and you spelled out other issues. Now, the question I'm asking that in light of your answer, would it be unreasonable to review that particular mandate, the mandate of Treasury and the Reserve Bank, in order to protect a Gogo Dlamini?
So the mandate I spoke about was the mandate on regulating banks and lending. It's an institution with multiple mandates, but you do understand, say, that this investigation was, as indicated in the transcript of my interview with Chris Stolz, just looking at collecting your debt. So reviewing the mandate of the bank in terms of its lending practices and debt collection would definitely not be unreasonable, sir. Okay, because that would be a logical connection with the wrong, because a remedy corrects a wrong. And as a public protector, we used to talk about righting the wrongs of the state.
Thank you. So I'm glad that we agree that it is not unreasonable to review that mandate to make sure that Gogo Dlamini is protected. Now, the investigation took more than 5 years. Is it something that is fair on the complainant that, the investigation and the issuing of the report takes so long?
It wasn't fair on the complainant, but it was reasonable. I kept, if you're talking about the real complainant, which is Advocate Paul Hoffman, he understood my constraints, because when I decided to buck the trend and undertake an investigation, it was clear that we were hugely under-resourced, and of course, I would have to fit it in together with the rest of my duties. And then, of course, Advocate Paul Hoffman was not happy with the delay, but he understood. And Michael Audley, who had triggered this investigation, was given the same explanation when I finally met him in September 2015.
Okay. Would you say the investigation was not prioritized like other investigations?
Repeat your question, say, sorry.
Would you say the investigation was prioritized or was not prioritized like other investigations?
It was far more prioritized than other investigations. If you are going to talk about my time, given the fact that I did not investigate, that was laid in evidence yesterday. You will see how many people I personally interviewed. It is again in the report, from the president of the time, President Begum. Chris Stolz can talk to you about how hard we tried to pin down the interview with him. And I took my time when I was in London for a different event to make sure that I arranged to meet Michael Audley. So definitely, but the approach at the Public Protector was twofold. Every investigation matters, but bread and butter issues matter most.
Okay. Why did you only work with a trainee and a young investigator in what you describe as a complicated investigation?
So, as I explained yesterday, this matter was rejected, and I did not want to burden my team that had used our triaging tools to say this investigation should not be done because it's a cold case. We didn't exist when the landing took place. The trail would be cold by now. And the possibility of recovering the money is next to zero. And this is taking into account that this matter had been the subject of an investigation by Heath and an investigation by Justice Dennis Davis, who both advised government against trying to recover. So the only reason, say, that I proceeded was because Paul Hoffman convinced me with the documentation that he heard, preliminary of course, that the money could be recovered through some kind of mediation and conciliation process. And that was the process under which I undertook this matter. And this is the process that I tried to pursue. You will see in my interview with Judge Bertelsmann, he himself admits that it is more of a moral issue than it is a legal issue when it comes to recoverability of the debt. And of course, at that stage, we didn't have the evidence of Chris Stolz, which shifted the picture a little bit. So
Okay.
it is not true what you're saying, with due respect, that it was not prioritized.
Okay. My question was, you were working with a trainee and a young investigator in what you describe as a complicated investigation, whereas one would presume that in light of a complicated investigation, you would want to utilize the best experienced and capable investigators. Is that not, is that correct?
Yes, sir. I would have done so if I believed that I could not handle the complexity. I could. I could work with others if I thought that they were not, there were some investigators that didn't have a huge backlog. Already, the team was struggling with a backlog. Statistics from the Pub Protector are available that will show that we shifted just about the same number of investigations as my successor, if not more. If you look at per capita, if you look at number of investigations shifted, number of investigators at the time. And I would like to tender those statistics, and I would like to ask the investigators, the evidence leaders to kindly request the public protector to submit today a 25-year report on statistics. So I couldn't withdraw any investigator from a matter that they were already handling.
In 7.6E of your affidavit, you mentioned that the SSA was never involved in the investigation. Yet you interviewed Mr. Billy Masetla from the SSA. Now, are you not misleading the committee by saying the SSA was never involved, yet you interviewed Mr. Billy Masetla from the SSA?
No, sir, I am not misleading the committee. When Mr. Masetla was interviewed, he was no longer with the SSA. He was interviewed, as I said in my evidence yesterday, that he was interviewed purely because he had been the one asked as the head of the predecessor of the State Security Agency to issue the contract, to be the contract owner of the original contract, which the contract, by the way, was not about what this investigation ended up being about. So I did interview Mr. Masetla just to understand, as the person who had issued the contract, number one, is it true that the money was not collected? Number two, why was it not collected? Number three, who made that decision? And we got the answers to all of that.
So you interviewed him in his former capacity or capacity of a person from the SSA?
Exactly, in the same way that you're interviewing me right now, sir, purely as somebody who has institutional memory.
Okay, so it's a different point. However, why did you not record the meeting with him?
As far as I know, it was recorded. I'm told that the record seems to be missing, as many recordings on this matter seem to be missing, including Michael Ortley's. But as far as I know, it was recorded because that was part of our standard operating procedures. But I do have my handwritten notes of that meeting, which I can submit to this committee.
Did it go missing during your term or after your term?
I don't know when did it go missing, because I was just informed when the evidence leaders were looking for information from me that Mr. Masetla's testimony is missing.
Okay. Talking about you recording or not recording your meetings.
It will be your last question.
I'm almost there, Chair. I'm about to wrap up.
Sure.
Did you record the tea that you had with Premier Magashule?
No, I didn't, because I never recorded events that were not interviews, but every event that occurred in my office was recorded. So if you go to my office right now, or my former office right now, and you request my diary, which was left there, it would record that Mr. Makashule came in, and it would record that he left. I didn't
Okay.
record the meeting because he said he had come to me for a cup of tea.
Okay. In 7.6b, you state that the tone, scope, findings, and remedial actions of the final CX report differed materially from your draft. Now, in light of new evidence that would have come up, would you expect that the report would have stayed the same?
No, I wouldn't expect it to stay the same. In fact, all I was indicating was that it has nothing to do with what I heard and what I would have heard. That's all. And I wasn't making a judgment on the fact that it changed.
Okay, last question, Chair, is that in your draft report, one of the remedial actions was to introduce regulation to prevent reoccurrence of the CX scandal. Did you support this remedial action?
Of course. I would have supported it if I had finalized the report, to the extent that it would be talking to lending. What I explained, Honorable Zungula, yesterday is what is in the standard operating protocol. You decide what happened, what should have happened. Is there a discrepancy between what happened and what should have happened? If so, shall we call it improper conduct? And if so, who was harmed? And how do we place them as close as possible to where they would have been but for the harm? We also would then look at, is there a systemic problem in this regard? So I would definitely support remedial action that was talking to future lending practices and debt collection, because this is what this investigation was all about.
Thank you. Thank you, Honorable Zungula and Advocate Madonsela. I now recognize Honorable Holomisa.
Thank you, Chairperson, colleagues, and our witness, Ms. Thuli. There are two questions. Yes. First question is, how did you deal with campaigns to discredit you and your staff by the ruling party during the Nkandla debacle? The second question is, are you not surprised, right, Laura? Are you not suspicious that now you get praises from the same party members who insulted you when you were doing the Nkandla report and the state capture report and called you names such as spy, agents of American, as well as, there were a lot, but the opposition parties stood up and defended yourself. That's my question, or two questions. Those are my two questions.
Thank you. Just wait, Advocate Madonsela. Thank you, Honorable Olomisa, for those two questions. Over to you, Advocate Madonsela.
Thank you, Honorable Holomisa. Just firstly, thank you for the support that you unwaveringly provided for the team as it did its best to pursue its constitutional mandate and the truth and justice. I will start with your second question, Sam. I'm not surprised that I get praised because we all deal with life based on the new information that we have. At any given stage in life, we act according to what we know, what we think, and how we feel. That's what neuroscience tells us. And I hold no grudges against anybody who dealt with me in any particular way at any given stage. They did so in terms of what they thought was good for them, for their party, and for the country at the time. And the fact that we differ about what we think is good for the country at any given stage does not mean we should always differ. When we have persuaded each other to see a picture that is beyond my paradigm and your paradigm, there's room for some kind of dialectical change. So I'm very happy about the changes that I see because they give me hope for our democracy. They give me hope for the country. And yesterday I worked until very late on the expropriation bill. So when I see people changing with new information, I think that we can find each other on seemingly intractable issues, such as the expropriation bill. It's 8 years since the African demands and 110 since 1913. So thank you for that. But on how did I deal with people who disagreed with me? Well, I would go to them. You will recall, say, that I would organize meetings with all of the parties in one room to indicate how we do business and why we do things. We would explain the procedure we follow with intake and assessments. For example, they would think I just sit in a little corner and decide what to investigate. Would explain them that there's a whole system of intake assessment, and all of the cases are sent to members of the team to approve or disagree with the intake and assessment team's decision. And it really worked because often, if I'm not wrong, we would issue joint statements with the governing party because it was big. We would meet with them. But one thing for sure, I always made sure that I brought my team in meetings with stakeholders so that they understood that I may be the professional who is appointed to lead the team, but I'm not necessarily the one with the brains and expertise to find all the answers. I rely on the thinking in the group, but ultimately, everything that I sign is what I believe is the truth and legally sound decision to make. So that's all I can say to you, Honorable Holomisa. Thank you for your questions, sir.
Thank you, Advocate Madonsela and Honorable Holomisa. We will take a 10-minute tea break and be back after 10 minutes. Thank you. We pause.
Recording stopped.
from the tea break. Colleagues, I'm now going to proceed with the members for the questions. Honorable Sukas.
Thank you, Chair. Good morning, Advocate Madonsela. I'm going to focus on some broad questions and not the narrow focus that you were called in for here. If you're not comfortable with the questions that I ask, you can just let me know.
As long as they are not bringing new cases here, you will watch that. Thank you.
Yes.
So that you stay on the issues, but we will see how you spice it, but we'll watch you if it's bringing new things.
Okay. Thank you, Chair.
Good morning, Honorable Sukas. Thank you, ma'am.
Advocate Madonsela, I recollect that you appointed, in evidence that was before the committee before, that you appointed a process engineer to look at process re-engineering work before you developed an electronic case management system. Can you explain why you did that and what the status was when you left the office?
Right. Thank you, Honorable Sukas. We firstly did have a case management system that was working amazingly in generating data about where our cases were at any given stage and what was the case backlog. However, it was not able to contain the volume, and therefore we then appointed a process engineer to look at what were the blockages, but also to do a little bit of futuristic thinking to say, these are blockages with the current caseload, but futuristically, how are the cases likely to multiply or contract? And therefore, what kind of platform would we need? And so that was the process they had to do. By the time I left, that process had been concluded. The next question was funding the new arrangement. And the good thing was that we had been assured by SAP that the platform was fine. It's a question of the soft engineering to design a system that was malleable enough or agile enough to handle this expansion.
It took us, I understand, more than a decade to develop a case management system. Can you explain why that process was initiated and why it took so long, really, for it to be developed?
Ma'am, it took long because the first thing was making a decision about what to do with the system that we had. We were struggling with, is the problem the entire system, which included the platform that was being provided by SAP, or was the problem the package or the software, the engineering that had been superimposed on the platform? So it took a while, and part of the problem was financing that process.
We had the Zambian public protector here who offered an opinion that adverse court judgments are an opportunity for an ombudsman's office to self-cleanse, she called it. Courts can be in error, and we've heard that argument over and over, I think, before the committee as well. And therefore, you have an appeal process. How do you believe an institution should deal with that? In particular, what would be your approach? Would your approach change as higher courts in majority or even strong judgments are being made, findings against the Public Protector's Office? How should it be approached? What are the factors that you would consider and weigh up in challenging judgments and instituting educational reforms?
Well, firstly, I agree entirely with what Advocate Sagani said in that particular context. Judgments are an opportunity to self-reflect and keep improving. How do you deal with them is exactly how we dealt with the judgment. We were not happy with the High Court decision on the so-called oil gate, which was the Mail and Guardian versus Public Protector. So when I came in, Advocate Mshwana had instituted an appeal, and it was expected of me not to proceed with the appeal. I proceeded with it because I needed clarity on the role and powers of the Public Protector, and I was not persuaded by aspects of the lower court judgment. And it then went on appeal, and a decision was made about what is a proper investigation. This is now part of my teaching. This is part of what I incorporate when I'm teaching on administrative investigations and commissions of inquiry. This is what we asked one of our investigators. I can't quite fully recall whether it was Advocate Matlawe or Advocate Rayandani, but one of them was tasked as part of our think tank to go and extract what was the judgment saying and then bring it to the think tank. And of course, my role was to quality assure it. That became the basis of how we taught ourselves about begin with an open mind, keep that open mind throughout, follow the truth wherever it is, and do not self-limit. Explore fully the powers that you've been given by the Constitution and the law. So it was an opportunity to reflect on how we do things. And I do think that judgments, it's true, may be wrong at times, but once the Constitutional Court has spoken, you have to fall in line.
I would just venture for one follow-up on that. You mentioned the learning from the Mail and Guardian case and how you have now incorporated it in your training and learning of your current work. But in terms of the Public Protector South Africa, is there any of the learning that has become part or entrenched in the organization in any way through systems or processes that when you left?
Honorable, it was actually entrenched in the Public Protector. It's just a spillover, ma'am, that I'm using it in my teaching. As I said, Advocate Matlawe and Rayandani are at the Public Protector. They, at my instance, distilled the principles. I think it's probably Advocate Matlawe because he was in the quality assurance unit. And then with my supervision and my own edition of how I understood the judgment, we then used it. It became part of our guidelines. Initially, for the longest time, we had guidelines that were based on the Mail and Guardian judgment, plus what we had learned at Sharpen Your Teeth training in Canada and a public admin international in London, among other things, including the IOI trainings. So it pretty much, if you look at the standard operating protocol that I designed and left at the Public Protector, the Mail and Guardian decision is at the core of what constitutes a proper investigation.
Thank you. Is it correct that a handover meeting with Edward Mkhwebane did not take place? And can you elaborate? I think you mentioned it last week.
No, ma'am, it is not correct. We did have a handover meeting with Advocate Mkhwebane, but it was short because the arrangements I had made for the handover were taken over by the storms of life. Honorable members and chair and Honorable Suka, you will recall that towards the end of my term, we had our own black swan, to use what the economists use when a sudden turbulence happens that just, pretty much redefines your operational landscape. And because of that, then the clean process that we had planned was interrupted by these emergency meetings, redoing the report, reversing certain things that would have been the findings, for example, the provisional findings that I had made that were in the Section 79 notice that had been given to President Zuma. All of that had now to be reversed in the report, in the circumstances. Because of that, then the full day that I had hoped to spend with my colleague was not possible. But the two of us agreed, in the presence of my then deputy, Advocate Kevin Malunga, that we would meet the following week. Unfortunately, she refused flat out to meet, saying that I was no longer public protector. There was I should have done this before I left. And I know it would have been better to do all of it before I left. So there was a handover, and I then submitted to her a written report that, to the best of my knowledge, gave her indicators of matters where, if she needed questions to be answered by me, that would be a map she would use to ask questions from me. Unfortunately, that did not happen.
I only have two more questions, Chair. Advocate, finally, my last two questions, this one has to do with funding. The role of an executive is to address the issue of funding. With the Nkandla judgment, the Scorpions disbanding, there were increased workload on the public protector. What sources of support or funding existed aside from the South African fiscus, and what were the advantages and disadvantages of using these sources?
Thank you, Honorable Suka. There were no other funds other than from the South African fiscus, and I welcome this opportunity because there's often been a public campaign that says that I received donor funds from USAID. No, USAID gives its donor funds to Treasury, and then Treasury distributes those funds to departments, and we used to get our budget from the Department of Justice. And of course, through persuading USAID, we got that kind of funding through the Department of Justice. That was for the case management system. So no money ever exchanged hands between the public protector and any donor outside the Treasury of the Republic of South Africa. Then there was pro bono assistance. The question was asked about leadership. When I first came in as a public protector, I had a clear mind that I wanted rigor balanced with promptitude. And because of the original nature of the institution, I felt there was a lot of emphasis on speed and not rigor, and that those who were rewarded for speed. I gave an example yesterday of KZN closing a whole lot of files because government had either said we didn't do it, or government had said we don't have the answers. And then, of course, they would be rewarded for the number of cases they had closed. And I didn't think it was right. But by insisting on how things should be done, it became clear to me that my team was not following, because leadership is influencing and inspiring others to think and act as required to achieve desired results. So I felt that the body language was suggesting that they didn't like the fact that I decided that then nobody's going to get a bonus until we fix the system. And with the advice of a total stranger who had managed under transitional circumstances, he just told me that if you want to go far, go together, but if you want to go fast, you can go alone. So that's the leader who then assisted us with pro bono facilitation of an exercise that led to understanding what really was our purpose as a perpetrator, which was really to achieve justice. And therefore, finishing a case when you have reinforced injustice is worse than not doing the case at all. And in the end, then we are on the same page through
Thank you.
pro bono facilitation.
Thank you, Honorable Sukas. Thank you, Advocate Madonsela. Honorable Heron.
Thank you, Chair, and thank you, Advocate Madonsela. Chair, I don't know if these questions were covered. I was struggling to get in the first hour of the meeting, but I really want to just ask some questions that I made Advocate or Professor Madonsela around the Freda Dairy investigation. We've had quite a lot of evidence presented to the committee around that investigation. And if I may just, the gist of it was that Advocate Saliers, who was doing the investigation in the provincial office, drafted several versions of a report where she did not find or implicate, or did not find any evidence or any reason to implicate politicians. And there was evidence from Mr. Samuel that you were not happy with the leaving out of politicians in the report. Then yesterday, I think in your evidence, you indicated that you had had tea with Premier Magashule, and he had indicated to you that then MEC Zwane was implicated or could have been implicated. So I'm trying to understand, was that the reason why you requested Mr. Samuel to take over the investigation and then to investigate the politicians? Did it come out of that tea with the former Premier?
Good morning, Honorable Heron, and thank you for your question. Firstly, I just want to say, no, that was not the basis for saying politicians should be investigated. In one of the early versions of Advocate Saliers' report, there had been an indication that one of the officials had said, ask the Premier. It was the Premier who was behind this process. It is in writing. I've asked now that the Pub Protector, and maybe I asked through one of the spokesperson at the Pub Protector for think tank minutes that deal with the Freda Dairy matter, and I was asked that I must ask formally through the evidence leaders, and therefore making that request to the evidence leaders to please ask for think tank minutes on the Freda Dairy matter and copies of reports submitted by the team to the think tank on this matter. So it's not that the politicians enter the stage very late after meeting Premier Magashule. There had been probably the very first draft that served at the think tank had mentioned the involvement of Premier Magashule. And then when I met him, he didn't say MEC Zwane is implicated. He said MEC Zwane was at the center of this. He has all the answers. So he didn't say he's implicated. He said he was the person behind the project.
Thank you, Professor. The committee's heard that there were several drafts of this report that were prepared by Advocate Cilliers, where she continuously kept the scope focused on the administration rather than the politicians, and that it was you that were unhappy with these drafts and requested Mr. Samuels ultimately to take over the investigation. But it seems that, and it's a pity we don't have Advocate Cilliers here, but it seemed that she was not able to find a basis for investigating the politicians, and it was really on your instruction that she or Mr. Samuel included the politicians. So if she was following the evidence that she had, how was she? I mean, how did your intervention assist us to determine whether the final draft of this report is an act of misconduct, when the initial investigator, Advocate Cilliers, continuously drafted a report that did not include the politicians? And it was really, if I understand the evidence we've had so far, on your insistence that politicians were included.
Firstly, it is not true that the first time politicians were mentioned was at my insistence. As I've indicated, Prema Mahashule was mentioned in the very first draft that served at the think tank. Secondly, the one version that was sent back that was now at the level of what she was presenting as a provisional report, or for consideration as a provisional report. It wasn't sent back because politicians were not mentioned. It was sent back because nobody was mentioned. It would say officials did this, literally nobody, whether official or politician. It had no names. The actors who did the wrong things did not have names or faces. So, but you write that in the absence of evidence that implicated the politicians, there would be no basis to drag the politicians into the arena. However, Honorable Heron, the Mail and Guardian case was about the failure to take into account what was in the public domain through the media. And the public protector was found to be at fault for ignoring the Mail and Guardian, which had broken the story and which had some information. So the standard operating protocol that was operational at the time was that any source of information must be followed. And in the public domain, politicians were already implicated. If we ask ENCA right now, they will give you a clip where one of the beneficiaries, an older person, was lamenting how they were brought into the scheme with the promises of hope out of poverty, how they had a meeting at the George Hotel in Pretoria and with politicians and others, and they were brought into the scheme, but it brought them nothing but pain. So we were not going to ignore what was in the public domain, because it's about beginning and keeping an open mind as an investigator. You have to have an inquisitorial mind, and you have to have some healthy skepticism.
Thank you. If I may just wrap up then, Professor, I understand there was allegations in the public domain, and so that is a basis for including political players in the investigation. Did you ever discuss with Advocate Cilliers why she continuously excluded the political players so that you ultimately had to sort of remove the investigation from her and hand it to Mr. Samuels?
It was not removed from her because of excluding political players. It was removed from her for not having done a forensic investigation. It is in the standard operating protocol that when there are allegations of impropriety that involve conduct failure, in other words, it's not beyond service failure or maladministration, there is an alleged or suspicion of corrupt relationships, you must conduct a forensic. And that hadn't been done. I spent a whole day training the team in Bloemfontein on this. And after it had been going backwards and forward, and it was still not at the level of rigor that was required by our own standard operating protocol, I asked that Mr. Samuel take it over. And this was not a judgment on Advocate Celia. She was an ace performer on early resolution. She had been in charge of early resolution. And if you see the stats that are going to be submitted by the public protector, contrary to what was suggested yesterday, we did exceptionally. It might even be better per capita because of star performers like Advocate Celia. But this was an investigation of a different nature, and we needed to comply with our standard operating protocol. But more importantly, the courts had already told us in the Mail and Guardian judgment what a proper investigation is.
Thank you very much. Thank you, Chair.
Thank you, Honorable Heron. Honorable Suela.
Thank you, sir.
Thank you, Chairperson. Thank you, Chair. Greetings to Advocate Madonsela and the colleagues.
Greetings, ma'am.
I have got one question, I think so. It's in relation with the quality reports and the think tank. During our deliberation with Mr. Samuels, he gave evidence that the incumbent did away with the think tank. What was the effect of the think tank in producing quality reports during your term? I want to check that.
Thank you, Honorable Siwela. The impact of the think tank on investigations was priceless. You can get this from minutes. As I indicated to you, one of my strengths is, of course, interpretation of the law and the Constitution. And the powers of the public protector is one example in that regard. But when it came to that think tank, different people brought different expertise. For example, there would be those that are coming with a lens of the understanding of the law of contract, the lens of understanding of common law, because although the
just a pause, Advocate Madonsela. Anybody that your mic is on. No, you want an opportunity. No, thank you. There was an echo here, so apologies to continue, Advocate Madonsela.
Thank you, sir. Honorable Siwela, I was saying, regardless of my strengths as an individual, having the different lenses that my colleagues at that think tank brought, allowed us to view each matter from multiple angles and multiple lenses. Time will not permit me to talk about different cases where I had a particular view, but when people brought their views to bear and reading directly from the cases that they had in their heads, it was possible to determine matters differently. Because at the end of the day, each decision was mine, but I benefited from the village. In Ubuntu, we say it takes a village to achieve great things.
Honorable Suela.
Thank you.
Thank you, Honorable Madonsela, for your response. Thank you.
She's not Honorable Madonsela. She's an advocate Madonsela.
Sorry, Chair. Sorry, Advocate Madonsela.
Unless there's something else you know that we don't know.
Maybe it's promotion, Chair.
Go ahead, Honorable Suela. Are you done?
I'm done because I'm covered by other
Oh,
honorable
okay.
members. Yes.
Thank you, Honorable Suela. Honorable Mananiso.
Thank you, Chairperson. Let me start by welcoming the team leaders and the supporting staff, and as well Advocate Madonsela. Chair, I think on other questions, I must say that I'm partly covered by other members. However, I only have one question for Prof. Madonsela. When she gave her testimony during the cross-examination process with Advocate Ndalimpofu, she related that she has inherited a well-run institution. However, she further said that the institution is not perfect. So I want just her to take us through what did she meant, and as well in future what needs to be done at the PPSA. Thank you.
Thank you. Over to you, Advocate Madonsela.
Greetings, Honorable Mananiso, and thank you for your question, ma'am. I do affirm that I said that I inherited a well-run institution, and for that, I thank my predecessors, Advocate Selby Bagwa and Advocate Lawrence Mushwana. By the time we got there, there was a very clear understanding that the Public Protector is not just there to inquire. The Public Protector has to investigate and provide remedies. So for example, Mushwana had left me to follow up on remedial action on the Nandoni Dam, and we followed up on that. Advocate Bakwa, among other things, he had really been strong on ethics, and that is one of the areas that we became very strong on. Thirdly, both of them had left the office with a highest standard of professionalism. I never got a sense that the team was politicized. And I can say right now, without fear of contradiction, that I had no idea whose political persuasions were. And because they really just dealt with these matters professionally. And for that, I thank my predecessors for not politicizing them, for conscientizing them about transformative constitutionalism and transformative justice, and for them to understand that they could make a difference. I also like the Ubuntu. People like Pona and Sekele would pay for complainants to come to the office with their own money, provide them food where necessary. So that was the culture that my predecessors had left. that were built on. And then Advocate Mishwana had then built the case management system, which sadly only failed because of capacity, not because of the approach. So what needs to be sorted out, because I noticed that there is still issues around thoroughness, around following the standard operating protocol. I would say one of the things that need to be considered is having regulations under the Public Protector to change the Public Protector Act if possible. And again, this is a recommendation, which I want to distinguish. When I was Public Protector, I could distinguish between when I was directing somebody because I had the power to direct, and when I was recommending, where I would say you should consider doing this because I understood this is now outside my mandate. So what I'm saying to you now is just a pure opinion that the act needs to be refined to streamline it, but more importantly, perhaps allow it to have regulations that can then streamline these processes. Secondly, there was a lot that was made about vetting. What I had recommended to Parliament and to the Department of Justice was an oath of office, an institution that is so powerful, as people that are not members, that are not required to be members of any profession. And therefore, the only way as a member of the Public Protector institution or family, you can be held accountable is through this process. You can't be, okay, you are a member of the IOI, which is voluntary, but I think we need to have an investigator, the investigator profession professionalized. And I've been talking to the Gauteng province, where I've helped them with their standard operating protocol on investigations, on forensic investigations, because I chair the committee, the advisory committee on investigations. I have also then recommended to the Public Service Commission that we could, let's professionalize this investigator brigade and have proper training that is accredited for this brigade in the same way that lawyers are trained. And then Parliament should fund.
I think you've well covered the points, Advocate Madonsela. Honorable Tlap.
Just the last thing, fund them, say, for a system if it has not been finalized, the case management system.
Thank you. Honorable Tlap.
Thank you, Chairperson. Good morning to you and the team that is there from the Public Protector, from the evidence leaders, my colleagues, and the public at large. Prof. Madonsela Dumela.
Dumela me, le kae, and
thank you. Prof. Madonsela, I'm interested in the operations during your tenure. Probably we should start on the think tank that my colleagues have just asked on. I just want to understand from you what you would say is the impact on the quality of the reports without the think tank. My understanding is that it has been dealt away with. Do you think it has got any impact?
Ma'am, thank you for your questions. I think this is one territory where it would be unfair for me to pass judgment on the quality of reports of my successor. All I can say to you, ma'am, is that my own reports and my own thinking was enriched immensely by the think tank. It could get a little bit heated when somebody reminds you, I used to be a magistrate, so I know what I'm talking about. But it was fun at the end because we spoke about learning and growing together. And definitely the quality of reports was far more robust than it would have been without the think tank. And over and above the think tank, we had the quality assurance unit that then had to to again review the reports.
Thanks, Prof. Now, my other question is that on issues of consequence management, what measures did your office then had or employed, for instance, where investigators could not meet deadlines?
Thank you, ma'am. There were cases where investigators met deadlines, and certainly the starting point, as Carvey says in the 7 habits of highly effective people, is seek first to understand. So I would want to understand, for example, there was a case where an investigator was struggling with meeting deadlines, and the immediate manager had had it and just wanted him disciplined and possibly fired. And of course, you don't want to overrule your leaders, but you want to know what's going on. When we had a meeting with the investigator concerned, we discovered that he had an autistic child, and they were battling to find an autism school. And that's generally they were battling with this new phenomena that is called autism, where a whole lot of cultural myths surround it, and you're a young couple and you have to battle with this. And therefore we then sought to provide a well-being support as a basis, and he became one of the stellar performers from that. And so in every case, you would follow the procedure of finding out what happened, the same way as we conducted our investigations. What should have happened? Is there a discrepancy between what was promised, which was the outputs, and what was delivered? And if there was, is there an explanation for this discrepancy, a valid explanation for the discrepancy or disparity? And if there's a valid one, then you correct the situation based on the outcomes of that process. Because the idea was not to break people or to make the organization a fragile organization. The idea was to make it a high-performing institution, but knowing that firstly, every human being matters, as Bob Chapman says in his book that says everyone matters.
Thanks, Prof. Now, my other question is on the processes of quality assurance. Mr. Tebogo Kekana, before this committee, indicated that for the Freire report, quality assurance processes were omitted before its final publication. Just want to hear from you, is it a problem? How essential, in fact, is the process of taking the draft reports through quality assurance before final publication?
Madam Klapke, thank you for your question, Honorable. I must again say I cannot comment on my successor's system. We all design systems to the best of our ability, but there was a standard operating protocol that said how things should be done. So if my successor amended the standard operating protocol and quality assurance was no longer a step in the SOP, and who am I to judge differently? Again, I just reiterate that for me, quality assurance was important. But earlier on, I was asked, what could I do to change the system? Of course, you need a robust system, electronic case management system, but you need each investigator to deal with the investigation as if they were the only ones who were to issue it. That's why training is important, because then if investigators don't do their investigation as if they were going to be the final authority on it, then you get a backlog at quality assurance, where they also have their outputs in terms of how soon should these investigations come out. Thank you, ma'am.
My last question, Prof, and me and you will just go around this thing of I told you that we're going to deal with the issue of operation systems. And you are indicating that you cannot venture into what your successor is doing. But I'm asking this because as and when witnesses came before us, it looked like this was problematic. That Memvuyana, for an example, indicated that on another report that was set aside by the court, the current PP kept investigation closed between 3 people. And going to the very same standard operating procedures, is it a problem, or was it normal, or is it okay to do that? Would you say, as a person who's experienced, it is a problem to keep a report, investigation report close to 3 people?
At the level of investigating Memklape, you may initially keep the investigation to 2 or 3 people because you're containing information flow. If it is an investigation where the leak of information could jeopardize the investigation. So that has happened with Nkandla, etc. But what then happens is that nothing, and I mean nothing during my time, ever went through without the normal quality assurance team. And the quality assurance team was investigators. So it didn't include my chief of staff or the CEO or spokespeople. It was investigators that had been regrouped into a quality assurance team.
Thank you. Thank you. That was the last question, but then I saw a hand dropping, and I'll give her 2 minutes. Honorable Gondwe.
Thank you very much, Chairperson. Good morning, Professor Madonsela.
Good morning, ma'am.
I have Thank you. I have 2 brief questions for you that are somewhat related. My first question is, during the course of this inquiry, we had evidence that the SSA was actively involved in the operations and affairs of the Office of the Public Protector. And I wanted to find out from you if you think it's important for an institution such as the SSA to be actively involved in the operations and the affairs of an institution such as the Office of the Public Protector. So a case in point, we heard how they sat on an interview panel and how someone from the SSA was seconded to act in the Office of the Public Protector. And at some point, the advice was solicited around the development of an electronic case management system. So that's my first question.
And since they are related, can you also deposit the second one?
And the second one is around a top secret security clearance for investigators. And I know you've alluded to this somewhat indirectly in the course of your responses, but I just need you to respond to my question. And my question is simply this. How important is it for investigators to have top secret security clearance in the Office of the Public Protector? And, would their not having a top secret security clearance, would you deem that as an impediment towards them being able to conduct investigations? Now, I'm asking this because we also heard during the course of oral evidence before the inquiry that the former DPP, Advocate Kevin Malunga, was, literally sidelined when it came to investigations because he did not have a top secret security clearance. So my question is simply, how important is it for, an investigator and even Deputy Public Protector to have a top secret security clearance? Thank you very much.
Thank you, ma'am. On your first question about the involvement of the SSA, I would definitely not involve them. And not because during my time, according to journalists, they issued three crazy spy stories that had no sense, including one where a judge was speaking incoherent English, and yet it claimed to be a transcript of my conversation with him as my handler. So that's aside from the fact that there was a time when the SSA had gone rogue, and that is during my time. But I would not involve any department in matters of the Public Protector, because the Public Protector is there to oversee compliance with the requirements of proper conduct in state affairs by all organs of state. And therefore, you want to make sure that you have an arm's length relationship. For example, the one department I had a relationship with virtually all my life was the Department of Justice. I had a relationship with that department long before I joined it in 1995 as the deputy head of the planning unit. But I would not involve them in because we had to oversee them. It's very important that an office, or it was important to me that my office was totally independent, but also seen to be independent. It was important for me that all my decisions were my decisions as advised by my team, of course, not even as advised by lawyers. There was no investigation where we even sought the advice from outside, except the investigations that were conducted by outsiders, but concluded by us. So yes, I would say no to the SSA's role in my time, but I'm not going to comment on what somebody else would want to do with that institution. The secondly, on top secret clearance, my own view, which was my submission to Parliament during the time of the late Ben Turok, was that vetting, we should introduce a vetting system that I had found operating, I think it was in New York, where you have an integrity unit that does the vetting, and therefore it takes it away from toxicity. Clearance, when I came there, the staff had not been top secret cleared. Then the Auditor General insisted, but still the majority of the staff were not cleared because there was a backlog in clearing staff. And there's absolutely no way I would have subjected my deputy to clearance, because it's not done to offices such as ours. It's not done to the judiciary. It's not done to the Human Rights Commission. It's not done to you, members of Parliament. And why? Because there's a process like this that the deputy, like myself, would have been subjected to, where members of the public would have been asked to submit anything and anything under the sun that they thought would be an impediment to him being appointed, or anything that made him or her not a fit and proper process, or not a fit and proper person to take that role. And I was asked, why subject my staff to a regime that I didn't want to be subjected to? I had to comply because of audit requirements. And of course, because of that, I had to comply with that. But I do think staff has to be vetted in one way or another. The staff, nobody takes an oath, which is one of the recommendations I'm suggesting, that everyone should take an oath from Public Protector to staff. It is an omission, and I did point this out to the Department of Justice. And before they take an oath, if
Thank
they wish to
you.
check them out. Yeah.
Thank you, Advocate Madonsela. I think that answer is well responded to. We thank you there. We are now, as we wrap up, I'm going to ask Advocate Mpofu to come back for any pickup questions as we wrap up. Thank you.
Thank you, Chair. Good morning. Thank you. Good morning, Ms. Madonsela.
Good morning, Advocate Mpofu.
Thank you very much. Yeah, I'm just going to do some pickup questions, but I just wanted, Chair, you saw my hand. I was trying to raise when Honorable Gondwe was asking questions, but I thought to save time, let me just deal with those issues now up front here. Just to assure you that the record will show that there's no evidence here that has been led that SSA was actively involved in the operations of the public protector. Neither is there any evidence that just a moment, that Advocate Malunga was sidelined because he did not have security clearance. That's just for the record, but we'll deal with that maybe when we summarize the evidence. Yeah. All right. All right. I think Advocate Madonsela, let's sorry, you'll forgive me. That's how we are used to addressing you. I think let me just start with the issue so that we get that out of the way. The issue of the affidavit that Advocate Mayosi dealt with. And particularly from, I know that you and I differ on the adage that context is everything, especially in interpretation. But I don't want to spend more time on this than is necessary. I want to take you to page 490. That's your first statement. Yes, can you go to, sorry, it's my fault. 193, I think, is the last page. Yeah, further down. Yeah, okay. Up a bit. Yeah, right there, right there. Okay. Now, you've been taken through the dynamics of the statement, so I don't want to waste time on it. I just want to refer to two important features. This statement, you know, firstly, you signed on top of the name, correct?
Yes, Advocate Mpofu.
Yes, and in fact, you misspelled your own name there, correct?
The person who typed it for me misspelled it. And
Yes.
We were in a hurry. It was Saturday, the deadline was at 4. I didn't see that. I was trying to chase the deadline.
Yes, that's fine. Okay, then let's go to then the the bottom. The date was the 23rd of February, 2023, the original date, correct?
The Commission of Oath mistakenly put 23rd. Then he realized he had made a mistake and put 25th and therefore changed it.
Yes, good. Okay, that's fair enough. And then because he made that change, then he initialed that change and made a mark there, correct?
Yes, sir.
And you made a mark against his mark, correct?
Yes, sir.
And that is to confirm that that change has been effected by both of you in the presence of both of you on the 25th of February, 2023, correct?
Yes, sir.
And you did that irrespective of the fact that on that same page, both your full signature and his full signature appear there, because that was for a different indication. The mark was for a different purpose, correct?
Yes, sir.
Yes, okay. So do you now understand what Regulation 4.1 means when it says when there's a mark of the commissioner, there's also the mark of the deponent?
No, that's not what it says, sir.
Okay, what was the purpose for, all right, what was the purpose for those two marks that you made there?
We made a choice, given what the Mohammed case says, we were not required by law, but we made a choice with this Commission of Oaths, because this is a different Commission of Oaths. We made a choice to sign together, or he made a choice because he was in charge of this process of the signing, as commissioners of oath are. He made a choice that I should sign next to him.
All right, yeah, but what
it was not legally compulsory in terms of Minister of Safety versus Mohammed.
No, Minister of Safety versus Mohammed has got absolutely nothing to do with what we're discussing. I'm asking about the Minister of Safety, and Mohammed talks about signing every page. But I'm not talking about that. I'm talking about the corrections you made, the marks you made on the change of date. What's that got to do with Mohammed?
Okay, sir. Minister of Safety versus Mohammed has nothing to do with what you are talking about.
Yes, thank you. All right, that's fine. Okay, fine. But you do, okay, as I said, I don't want to spend much time on this. All I'm saying is that despite the fact that both your signatures in full appear on that page, you both found it necessary to sign and countersign against the alteration on the date. All right.
Exactly, which has nothing to do with either the regulation or the Minister of Safety.
You just did it for fun.
We made an election, or he made election, and I complied, which is what Minister of Safety versus Mohammed says.
No, Minister of Safety and Mohammed says something about alterations on affidavits. In your estimation?
No, it says nothing about alterations. That's why I do. Neither does the regulation that you cited say anything about alterations. That's why I don't quite understand. Maybe you should repeat your questions there, because I don't know what you're trying to say. I don't know what you want me to answer.
Just answer the question. You don't have to know what I'm trying. I'm not trying anything. I'm asking you a question. You just answer it truthfully and honestly, as you saw at the beginning of these proceedings. Okay, let's go then to the next statement. That's the one of page 486. Now, let me ask you this. You know that these proceedings are very important in the history of this country and unprecedented, correct?
Absolutely.
Yes.
All proceedings are very important as far as I know. That's how I handled my cases as a public protector.
All right, that's fine. Okay. But you do know that in posterity, people will look back at these proceedings probably as a reference point when any impeachment or if any impeachment occurs, because well, you might not know the history of how the rules came into being, but at least it's predictable that this will be a reference point, correct?
I really don't know. It might be immediately superseded by another precedent. I really don't know what the future holds there.
Yeah, no, that's fine. That's fine. All right. Now, tell me, if somebody in 100 years, not now, comes across the affidavit 486, comes across that affidavit, okay? And they read, you explained this on page at 486, yeah. There's the 2 marks and a mark below. Let's go to the next page because that's the more important one. Yeah, start at the top. You've changed that. There's an insignificant change. You changed the word summons you. It was your to you and remove the R, correct?
No, sir. Please, you must read the originals before you make these allegations. Okay, what were you signing against there? But when really, you should have read it before you make accusations, sir.
Advocate,
just a sign there.
Miss, whatever you are, please answer the question. What were you changing when you signed next to that at the top of that page?
I was changing the sign, the accidental sign that in the computer is in the same space as a period. That was the sign there. And it was shown this morning, sir. Are we going to rehash something that was shown to this committee this morning?
Please answer the question. What were you changing when you signed?
I was changing what was shown to this committee this morning and was adduced by Advocate Mayosi, which was a sign that is in the same key on the computer as a period sign.
So why are you answering differently from what you were answering when you were asked by other people? What's so difficult about telling the committee what you were changing? So it was a period, okay, and you signed against it. And then at 7.3, what were you changing there?
Sir, I'm not answering you differently. You firstly, on the record, said I changed an R. I said to you, I didn't. So to my colleague earlier, I answered yes and no when she was showing things on sign. She never accused me of things that I hadn't done.
Okay. What were you changing at 7.3?
As you can see, there's Paul Hoffman, and out of respect and professional courtesy, I thought we have to say Advocate Paul Hoffman SC.
Yes. And okay, sorry, just go back to paragraph 5, sorry, Tshepo. And paragraph 4, there you were changing, I think, let me rather lead you. You were changing a small letter C to a capital letter C, correct?
Yes, sir.
And then in the next one, at paragraph 5, that was not a cosmetic change like the others. It was changing the date from the 1st of February to the 21st, correct?
Yes, sir.
Good. So we can safely say, and then 8.3 again is just you're changing a Y. I'm sorry, or a letter. I'm scared now of even identifying the letter. You're changing a letter of the alphabet at 8.3, taking it off, correct?
No, sir. It doesn't take a letter of the alphabet. As it can be seen in the version that was aired this morning, it was the, which is THE, which was changed to they, which is THEY. So a letter was added.
Okay, so you're adding a letter of the alphabet. And then at 9.6, you are taking out a letter of the, or you are adding a letter of the alphabet S, correct?
Yes, sir.
Right. So we can safely then say that that was a collection of, let's call it, one substantive change, and some of them just grammatical or spelling changes, correct?
Yes, sir.
Right. Now, I'm saying, and I'm saying this in relation mostly to the substantial change. Oh, and then of course, you also changed another letter of the alphabet on your name. It was no longer Nomkoso Madonsela, but Nomkosi or Nomkoso 1, whatever you're changing the letter O to I suppose, correct?
Yes, sir, which is aligned to the heading of this affidavit.
Yes, right. So those changes, now I'm saying, if someone reads this affidavit, all right, let me just make it, all these changes you made here, substantial and not so substantial, you did them on the 28th of February or the 1st of March, correct?
Yes, sir.
Yes, what? Which one is it?
Well, the changes were done by me before the 20. I must have done them on that Sunday when I came back from some event, but could only then have a commission of oath for the electronic version much later.
Okay, good. So you did them on the 26th of March, of February, according to you. And then they were only commissioned on the 28th. Right?
Effectively, this affidavit, when it was submitted, was not meant to be the affidavit. So my understanding is that before this committee, there are two versions of the affidavit.
Oh, I thought there was one.
Can I just finish? Because this was what I said in my email, isn't it? There are two versions of the affidavit. I'm submitting the electronic, but for ease of reference, I'm also adding the hand changed one, so that because of the speed with which things needed to be done, it should be easy for the committee to look at the version of the 28th and say, where have the changes happened? I was trying to prevent the hullabaloo that ensued when a belief was entertained that the affidavit had been changed and it was now a 9-page document. So I wanted to keep it clear, this is the change, but what I was submitting for this committee's consideration was the electronic version that was again read this morning.
Yeah, well, that cannot be true, madam, because the hullabaloo that you're referring to only occurred after 10 o'clock or after 10:30. You did this, you say, on Sunday, 2 days before, or were you predicting a hullabaloo?
No, I was trying to prevent the hullabaloo. It happened anyway, because my intention was to not stress this committee. by submitting a new affidavit.
Yeah.
Number one, an affidavit has to be submitted 7 days before parties. So I'm submitting a new affidavit that for all intents and purposes satisfies the requirements of an affidavit. But for this committee to entertain it without stress, they needed to know what's the difference between that affidavit and the one of the 25th.
All right. Okay. That's fine. So, okay, for now, let's accept that as your explanation. But you would accept that somebody who reads this affidavit 20 years, 30 years from now will make the following conclusion: that there is an affidavit which has those changes, and those changes, at the bottom of that, there's a signature of the Commissioner of Oaths, and therefore those changes were made on the 25th of February, 2023. You would admit that, correct?
No.
Okay. Now, okay, so if someone walks in now where you are there in Stellenbosch and takes this affidavit, looks at it, sees all the changes, 1st February 2023, and everything there, and then at the bottom it says Thuli Madonsela, and then it has a sign of Commissioner of Oaths, 25 February 2023. When are they going to think those changes were made?
Well, I don't know. I think a reasonable person would inquire.
No.
Are we talking about a reasonable person or an unreasonable person?
I'm talking 100 years from now, we will all won't be here. I'm saying that reasonable person who picks up this affidavit, when are they going to say those changes were made?
I think they might think about those changes in multiple ways. If they think in complexity terms, as I expect reasonable people, especially lawyers, I would think that they might think it could have happened anytime. And if they were reasonable people, they would inquire. They would not assume.
Okay, let's say a judge then, who's prima facie a reasonable person. If a judge sees this affidavit like this with all these changes, when will he or she think that they were made?
I would expect a reasonable judge to want to know who made them, because a reasonable judge would want to know the genesis or genealogy of the affidavit. Because in fact, a reasonable judge would be like me as a pub protector, because as a pub protector, I knew people could manufacture documents. I would therefore never presume when things happened. I would investigate.
I see. But you do accept, at least since you don't want to answer that question, you do accept that when you make these signatures and marks and all that, it's really not for your own edification, it's for the reader out there. A judge or whoever might read this in 100 years or 200 years time, or the chairperson or whoever will be reading the record. Let's assume there'll be a review, whoever might be reading a record. When you sign there, you're signing for that, you're communicating outwardly to somebody else, correct?
Say no, I don't sign a right for. I disagree. I don't sign or write for posterity. I write to communicate with the people that I'm communicating with. And that's why I took extreme care to send 2 versions of the same document so that they would not be confused as to this clean document, which had been properly signed according to the Mohammed case, but now they would have to wonder, what's the difference between this one and the one we received on Saturday? So I was communicating with those people, and that's what I do. I never do anything for the public. I don't play to the gallery. I am present where I am supposed to be.
All right.
Thank you, Advocate Madonsela. I just have 2 hands. Just a pause, Advocate.
Okay, Chair.
Advocate Mayosa.
Chair, thank you. I'm just struggling with this line of questioning. Given the current context of this affidavit to these proceedings, I'm struggling with what relevance it has, what a reader might think of it in 30 years' time.
Okay.
You drop your hand, okay? Yes, Advocate Prof.
Yes. No, Chair, well, I'm not here to cure Advocate Mayer's struggles, but the reason why I'm asking the question is that the affidavit, or okay, the document that we're reading, although the witness is evading the question, is any document like this, Chairperson, when you sign, that signature is meant to communicate something to somebody, at least I hope. You don't just sign, you're signing to say to whoever reads the document, because you can't, when you read affidavits, you don't go back to every time you read an affidavit in a court case in the constitutional court or whatever, then you have to go and inquire from the people who signed that document. That's just absurd, yeah. So when you sign an affidavit like this, you are communicating to the reader, really, something, whatever it is that you want to communicate. And for example, when they signed with the Commissioner of Oaths against the change of the date, they're communicating to whoever it is that although it might look like the 23rd, now it looks like 25th, but we corrected this, and then we all know. That's how I know. I wasn't there. I know it because I can read from this. So the question is very simple, and the witness knows the answer, but she chooses not to answer it. That when you read this affidavit, you will know, or at least you will read that there were corrections made, yes, and they were made on the 25th of February, 2023. But that will be false, because on her new version now, they were made on the 26th. So we now have three versions. One was done on the 23rd or 25th, whichever is the correct one. The second one on the 26th, and the other one on the 28th. And that's all I'm trying to portray. It's very obvious, actually. But if Advocate Mayos is struggling with it, well, there's very little I can do.
May
Okay.
I respond? No, Advocate Powerful, you said yesterday you're not going to make an allegation and then leave me dry. So
I
may
didn't
I
make, Chair, why are you addressing me? Chair,
Chair, may I please respond?
Chair, I have not put any question. I'm going to put the question now. So then you'll respond to the question, ma'am. Okay, maybe just for your assistance, I was going to move to something else so that I give you an opportunity to respond. You, Advocate Madonsela, are disputing the fact that anybody reading this document would be left with the impression that these changes were made on the 25th of February, 2023, which impression would be false. Is that your evidence? So that we can move on. Yes, okay, good.
I don't think people
now
have
you can explain,
mind.
sorry. Yes, you can explain. Yes, ma'am.
I don't think everybody has a single mind. Firstly, just going back to, if I communicate with intention to convince the person I'm communicating with, then I agree with you, because this was sent in communication with the evidence leaders, and it was also sent to the legal team. So a reasonable person would take this document with the email that was sent to them to say, we are sending you two documents. And because this document was not even, at the time, it was really the sort of photocopied. And therefore it became one document with all of with the final document. So a reasonable person would read the email first and understand, okay, the document that is being proffered is the affidavit is the corrected version of the 28th, properly signed by a Commissioner of Oaths. And then this document is not being proffered as a document to be relied on because it's only telling you, the owner of the electronic version, what are the changes. So a reasonable person would want to know the context, and chances are they would find these documents together. I mean, of course, an unreasonable person, I cannot be held accountable for how an unreasonable person would twist a simple matter into a complex matter.
Okay, so only an unreasonable person would think that the 25th of February means the 25th of February. Okay, and all this, what you're saying, would come from your email, which simply reads, "Dear colleague, kindly receive an edited version of the affidavit. I apologize for the errors in the initial one." Or what you've just said, you say, is encapsulated in that email, correct? For the reasonable.
A subsequent email indicated what is the relationship between the two documents.
Right. Okay, ma'am. Let's move on. That's fine. I think the facts speak for themselves. Now let's come to your favorite.
No. Wait, Chairperson. A reasonable person.
Madam, please let me finish. Then you can interrupt.
Okay, let me pay attention to Advocate Madonsela.
I'm saying a reasonable person would not split a document, because just as when the document was received, it was thought to be a 9-page document. Honestly, good people, a reasonable person would look at the document and realize that it's not a 9-page document, it's 2 documents. And they would want to then understand what is the relationship between the 2 documents. I therefore deny what Advocate Mpofu you are trying to do here. Are you trying to run away from the fact that yesterday you misled this committee about what is required to make the affidavit of the 28th an affidavit, and you're now shifting the goalposts to the corrected affidavit?
Thank you, Advocate Madonsela. Advocate Mpofu.
Well, Chair, I don't know why you want me to say anything, because I don't know what the witness was responding to. I just uttered 2 words and you allowed her to interrupt me.
She wanted to address the chair and I've allowed it.
No, she was responding to what I was saying.
She asked for a permission to speak and allowed her.
In the middle of my question. Okay,
like
fine.
Anybody does.
No, it's fine. I want to ask that question again, because you and the witness seem to know what the question was and even the answer. All right. No, it's fine, ma'am. Let's move on. I won't ask you what I was trying to ask you, because you interrupted me with permission. All right. Now let's move on then to your favorite topic, the one you're saying I'm running away from. Sorry, Chair, I'm just looking for my judgment. Right, that is do you persist with your version of yesterday that you are not aware of the practice that both the deponent and the Commissioner of Oaths sign every page? Or are you aware of that practice?
Advocate Mpofu, you are distorting my words once again.
No, just answer the question, ma'am. Don't insult me.
I don't persist with a version that I never offered, say.
Yeah, then say so. You don't have to insult me, madam. You just say yes or no, and then I give your explanation. There's no need for you to insult me. I feel nothing to be insulted by someone like you. So just don't do it. Just answer the question.
But
sorry,
Chair?
just
Chair?
a pause, Advocate Madonsela. Advocate Mpofu, yesterday I did ask that the language is toned down.
when I speak the language, you'll allow me to.
Are you
be
going to
insulted.
listen to me,
No,
Mr. Mpofu? Are you going to listen to me? And once I do this, I'm going to ask you to wrap up also. It's not proper that you use such language in this inquiry. To even go on and say you're not insulted by somebody like you. It's really not in the space of parliament that we can allow that. Yesterday, she used a language that says it's another low to you, and I called her to tone down and stop doing that, which she did. I can't allow this to continue in the same inquiry. So I'm asking you to please tone down the language.
Anyway, okay, Chair, you are completely unfair because you allowed her to say something about my standards and what have you. Now you are, up in arms to defend it. That's fine. Ma'am, let's just come back to the business of the day. I'm saying that the case of Mohammed also refers to the practice of signing on both pages. You aware of that?
Yes, I am. I cited it yesterday, sir.
No, you okay.
Just before you proceed. Okay, I was just going to ask you to switch on your video because it was off.
Okay.
I was not sure what was the difficulty. Thank you. Proceed, Advocate.
Thank you, sir.
Yes. And are you also aware of the practice referred to in that case?
I am aware, sir. Yesterday, you didn't ask me about the practice. You said to me, you are a public protector, and in all of your years as public protector, are you aware of any case where the Commissioner of Oaths and the deponent did not initial every page together? I said, I don't know. I didn't check everything, and which means I was right that there may be cases where it wasn't done, hence the Minister of Safety versus Mohammed case.
All right.
This case would not have happened if there hadn't been instances when somebody didn't do it.
All right. Okay, ma'am. So, okay, fine. At least now you are aware of the practice. Firstly, that's not what I asked you, but that's fine. The record will speak for itself here. Let me just assist you as to what I was talking about. Or at least do you accept that in the oh no, let's do it like this. And you remember me saying yesterday that that question was not aimed at a question of validity. You remember that?
Oh, it wasn't, because throughout you were talking about illegality, and if it's illegal, according to the law, it's valid. That's the principle of legality.
Oh, ma'am, please, man, listen to the question. Please, I'm begging you.
Okay.
Did you hear me yesterday saying that when I raised these 4 or 5 pointers, it was not only about the question of validity? Oh, you didn't hear me. If you didn't hear me, you didn't hear me.
Oh, please repeat yourself, sir.
For the 3rd time. Did you hear me yesterday when I said some of the issues I was raising had to do with the, let's call it, the conduct of the Commissioner of Oaths and you as the deponent, and not only about the validity of the affidavit?
Oh, I heard you malign the 2 colleagues that signed and suggested there may be some criminality. Is that what you're referring to, sir? If not, please repeat yourself. What exactly did you say? Just refresh my memory. You said a lot of things, sir.
That's fine. No, it's okay. I can't repeat it for the 4th time. Yeah. Anyway, the law is very clear on this, that when it comes to a question of validity, something might be allowed, but there is an established practice. And that practice, I think you and I went through it, among other things, is meant to prevent forgery or someone manipulating other pages and so on. That should be obvious. That's why we initial every page, correct?
You said that, I think, or something to that effect.
Yes, yes. Do you agree with it?
It is to authenticate, and of course, each circumstance differs from another. In this particular case, having with the commissioner, having the original and having the original signed by another commissioner and me being present there made it just easier to quickly do this and running against time. So yes, the practice, I guess, has a reason. Everything has a purpose, but there are outlying situations as happened in the Mohammed case.
Yes. Okay. Well, the evidence leaders seem to suggest or to support your you and the commissioner's deviation from that practice. And I just want to tell you that the evidence leaders, just as a matter of interest, in this committee have presented statements where both the Commissioner of Oaths and the witness signed on each page. And that includes the person you called the young investigator. The following statements are signed by the commissioner and the witness on each page. Statement of Mr. Tebucho Kekana, dated 18th July 2022. The statement of Mr. Vusi Mahlangu, dated 2nd August 2022.
Just a pause. I've got Suppose, Honorable Milam, there's a point of order.
Thank you, Chair. Chair, I'm sorry to interrupt Advocate Mpofu, but we've now listened to this go on for 4 hours about the affidavits. And frankly, I'm at the end of my patience on this. We know the issues, we've ventilated the issues, we've heard the various responses. We know what the concerns are that Advocate Mpofu has with the affidavits. We know Advocate Madonsela's response. I fail to see what going through it another time accomplishes. We know the law, we know the situation, and we've now spent over 4 hours on this one issue. Thank you, Chair.
Thank you, Honorable Milam. Advocate Bauer.
Chair, we will confirm as evidence leaders, we followed the practice. I can, if you wish to say this on other occasions, I haven't followed the practice.
On that, just hold both is not complete. I want you to conclude.
Thank you, Chair. I think this is just a waste
note of your intervention, Honorable Milam.
Yes, thank you, Chair. Yeah, well, this a waste of time in the name of saving time. Yeah. The statement of Futana Tebele. 4, the statement of Baldwin Nashunji. 5, the statement of Liwani Chaulula. 6, Dicheni Raidani, Reginald Ndo, Basani Baloyi, Ponatseho, Ohalad Mundus, Tolan Torseng, Nelisi Watajane, Niels van der Merwe, Freddy Nyatela, Ronald Lamola, Bianca Mviana, and Mr. Siabi. All of them are signed on every page by the
Do you want a response to that?
No, can I finish?
Yeah, please hold back, Advocate Madonsela. Conclude, Advocate Mpofu.
Right. In each of those statements, both teams that are here have caused and there's one exception, just to be fair to you. There's one is Mr. Samuel had 2 statements. One of them was signed by the deponent on each page, other one was not. And the other exception is you, Advocate Madonsela. But on each of the names that I've listed to you, and we didn't pick up earlier because we only did this analysis yesterday, the deficiencies in Mr. Samuel's statement, but that statement is not what the paper is written on for other reasons. But on each of those statements, the teams here ensured that there is that. And the point I'm making, Chair, is a very serious one, which is that whether it was the evidence leaders or ourselves, when we offered our assistance to you, Professor, then you could have been sure that from what I've just told you, that what you call the hullabaloo this what is annoying Mr. Milham would not have taken place, because I think this is ample evidence, whether it was them or us, the statement would have been done properly. Do you accept that?
No, I don't, because I don't know how you do things. There were mistakes in the letters. There've been mistakes in how you have read things here. So how could I have predicted you wouldn't have made mistakes?
Thank you, Advocate Madonsela. We'll get your answer.
Thank you.
Advocate Mpofu, I want you in the next 6 minutes to wrap up, which will be 12:30. We're supposed to conclude at 12.
Chair,
Thank you.
No, well, I'm going to need more time, Chair. I need to deal with.
No,
that was just one. No, Chair, there was, okay, there were 3 segments of issues. One, segment A was the issue of the affidavit, which was dealt with by Advocate Mayosi. I've dealt with that. Segment B was
I want to assist you so that you don't waste any more time.
No, I'm not wasting time, Chair. Can I finish talking?
Please
Come on,
conclude, so
guys.
that I'm
Please.
I'm going to make a ruling. Please conclude. Please conclude, Advocate Mpofu.
No, it's fine, Chair.
So I'm asking you to conclude at 12:30.
Yeah. All right. Okay. Madam, you, I think, did not answer the question that was asked by Honorable Holomisa. At least you said you don't hold grudges and so on, which is fine. But I think the gist of the question was whether you don't find it strange or you're not surprised that the same people who insulted you during the Nkandla debacle and called you names and called you a CIA spy, whatever, and still call you names and sometimes even objectionably referred to your features and all sorts of despicable things, and called you Umakoti was a Stellenbosch and Tombe Bugekayo and all sorts of things, degrading names, that those people are now praising you. And I think the gist of that was not that you hold grudges. I think admirably you don't hold grudges, but the question was whether do you find it strange or expedient that those people are driven by expediency, that they are now suddenly your #1 fans.
May I respond to that? Chair, allow me to say that even by your standards, Advocate Mpofu, this was the lowest.
Chairperson.
You conceived as an advocate of the Supreme Court of South Africa to bring insults that have been into the public domain, into this.
Advocate Madonsela. Advocate Madonsela, just
yes,
pause, please pause. Please take a breather. I understand what the challenges are. I did ask you yesterday not to get to that level, And
I apologize, sir.
I'm asking again.
Okay.
I apologize and I withdraw.
Please proceed.
Apology accepted.
I apologize.
I wanted to
Mpofu.
conclude. I wanted to conclude. Please conclude
Yes,
your response, Advocate Madonsela.
Advocate Mpofu, I am shocked beyond measure that you, as an advocate of the High Court of this country, have taken slurs that have been said to me. A lot of the things that you've said have never been said in Parliament. The one slur about my looks that you have repeated in this record that you yourself have said you envisage to be here for 100 years. You have brought what President Zuma said about my looks in the streets into this record. That is shocking and that is unprofessional, sir.
Yes, thank you. Is President Zuma a member of the ANC?
It doesn't matter what he is. I'm just saying, sir, you've taken what a street fight and brought it here. Firstly, you have reduced my response to what was said. I didn't say that I have forgiven people or something. I said people change. You and I were on the same side on one issue because we understood the same. When you litigated on the Public Protector, we approached you to persuade you about our interpretation of the powers of the Public Protector. You accepted that and you used that and we won the case. Today you are on the other side because you have been persuaded differently. So my response, which I repeat again, is that it's not about I hold no grudges. It is about I am not surprised, because that was the question that I was asked, are you surprised? I am not surprised because I expect MPs and lawyers and reasonable people to change their mind when they get new information. What we do, I repeat again, Advocate Mpofu, depends on what we know, how we feel, what we think, then we act. And that changes every day. At least this is what neuroscientists say. So it's not just about I bear no grudges. It is about we deal with issues as we deem fit. And I am glad that MPs are not stuck in yesterday. They are here, right here in this room, trying to make sure that South Africa works for everyone.
Yes, no, thank you. Well, for the record, I'm not on the other side. I'm just representing Advocate Mkhwebane. I don't regard that as being on the other side from you. But, and also, in case you missed it, the adjectives that I used about it being objectionable and despicable should show you that I don't agree with those epithets. For example, I don't agree that you are a CIA agent. I think that's ridiculous.
I disagree with you. You are elevating those things once again to this room and putting them on the record. Well, that is unprofessional, Advocate Mpofu. Shockingly, shocking.
No, that's fine. Well, you can insult me as much as you
like.
I think
shocking.
I've told you that what that does, it's water on the duck's back. All right, you can insult me all day, ma'am. Now, as far as Friede is concerned, you say you thought and you considered that politicians should be investigated, and we now know that the Advocate Mkhwebane did not just think, but he actually went and investigated the politicians and also went to the site of the Friede dairy farm. Now, what I wanted to ask, I was going to give you references. I want now, because of time, of the conversation you and I had on the Section 7.9 responses of Mr. Magashule and the MEC, which you had said you would, if you had seen those, you would withdraw the snide remark you made yesterday about their names disappearing. But because of time, we'll probably have, I was trying to avoid having to do that in writing, but we will write those to you and we'll submit your responses to the committee if the chair, in the interest of time, will allow. So that's just, I'm just informing you that, you understand, ma'am?
I fully do. And also about going to where victims are. I went to Gliplands where nobody was going because it was the killing fields. Even my staff didn't want to go. So you're not going to say that because I didn't meet this particular set of complainants, that is a judgment on me. And again, Advocate Mpofu, this is not my impeachment. It's your client's impeachment.
And it's shocking, yes. No, okay, my last topic then is what I call, what Madlanga, Judge Madlanga and Chief Justice Mogoeng called the magnification of the errors or mistakes made by Advocate Mkhwebane, by judges and other people. Now, you would agree that of all the things that you could be accused of as a public protector, probably the highest would be that you were biased and did not approach an investigation with an open mind, because that's probably the worst thing. Forget about making an error of law or not understanding the law and all that. But if you are biased, that's the ultimate, correct?
I would agree that the highest accusation that could be made is that you clearly favored someone and worked with them to achieve a particular result.
Yes, that's otherwise known as bias, correct?
It's not as simple as that.
Oh. Okay, do you know or don't you know, if you've ever done administrative law, that bias or the nemo iudex principle means not approaching a subject with an open mind and being biased?
Yes, I was saying,
okay.
The highest accusation that can be made against you as a public protector, as a judge, as a lawyer, a young person who wants to be a fit and proper person, is that you lied under oath or you lied generally. That's why you get struck off the roll if you're dishonest. So that even during the times of Plato, one of the virtues that was regarded as one of the highest virtues in society was honesty, because without honesty, we have nothing.
Correct. Good. And you would gather
going to be our last point.
It is the last point, Chair, but please allow me to develop it.
We were going to be closing now.
And you have been, as we gathered yesterday, Judge Potterell found you to be biased.
She did, and it was not appealed. And for the person who will benefit from that judgment being not appealed to claim a benefit from it doesn't seem right to me. I think John Rawls would disagree with that as just. If you've pursued another person's interest, as I did with Advocate Mushwana, with an eye to justice and to role of the public protector to the ultimate, and then come back and said, I did my best to get to the bottom of this, then you can come here and say, yes, I put the best of counsel in this case. I did my best to have it appealed, but it came wanting. I even got you involved to explain yourself, and you can't
Yes.
give me any of that.
All right. And the giants that you say you walked on the shoulders of, at least one of them is referred to by Professor Hoekstra as the ANC protector. That would be Advocate Mushwana. And do you know that this is what the SCA, talking about appeals, said about his investigation? An investigation that is conducted in that state of mind might just as well not be conducted at all. The investigator is then no more than a spokesman who adds his or her imprimatur to what has been said, which is all that really occurred in this case. I have said before that an investigation calls for an open and inquiring mind. There is no evidence of that state of mind in this investigation. In other words, he also was accused of bias, apart from just being called the ANC protector. Is that?
May I respond to that?
Yes, of course.
I think it's unfair to malign Advocate Mushwana here without having warned him. The Mail and Guardian case is a case that we use. I've never suggested that the giants on whose shoulders I stand were correct in every way. In fact, the statement said that we look to them to the extent that their way is a better way. But when we found a better way, we do things differently.
Yes.
And if you didn't read my statement and you did not understand the import of my statement, then I'm sorry, sir, because my statement was a 4-page statement, and the last part of it was very clear about not suggesting that my predecessors were correct in every way.
Okay, my last question then is this, that you, well, for the record, both your giants did not obtain clean audit, including you as the giant admirer. But as far as you've also said that you've had accolades from all sorts of bodies. Is it true that one of the accolades that you also received and got was to be named the Person of the Year by the Guptas?
Oh, certainly, but the accolades that I mentioned
were
by my peers.
Just pause, Advocate Madonsela, before you respond. Thank you, Advocate Mpofu. That would have been your last question. Please respond, Advocate Madonsela.
The accolades that I mentioned were the accolades that are relevant to this inquiry. I was asked if I consider myself an expert on, or my strength being the interpretation of the law. I said yes, including the interpretation of the Constitution, and that shone through in the powers of the power protector. I am the inventor of the Equality Code. I have drafted many laws and been part of drafting many laws. I defended the Equality Act in Parliament, and you'll find that in parliamentary records. And I then, in that particular context, mentioned the accolades that have been given by my peers. And it was the Law Society that approved me in terms of my interpretation of the law, the Judge President Lidwaba speaking on behalf of the judges. And then I got the Commonwealth Lawyers Association Truth and Justice Award. I got the Sydney Kenridge Award. I got the Transparency International Integrity Award, the APRM Award, the Association of Certified, the Association of Certified Forensic Investigators Award. And therefore, this was mentioning my peers. Again, I don't like the idea of drenching things into this committee. To you, Chairperson, thank you for the opportunity to assist.
Just pause there. I'm coming back to you. Thank you for responding to that last question. we have now reached the end of our interaction with you as our witness. Before I thank you on behalf of the committee, I want to ask you to say your final remarks and comments to this committee.
Firstly, thank you, Chairperson, honorable members and colleagues, for the privilege to be a witness. I came here as a reluctant witness. I was shocked that for the bulk of the 1st of March, I was the accused person watching on this platform, unable to defend myself. For the bulk of yesterday, I was the accused person. But nonetheless, I do hope that what I have shared with you about what I know about the glorious institution, but not flawless institution that I inherited, I have shared with you today. I also hope that I've assisted you to get a sense of what I did with the 2 reports that you've asked me to be involved in. I was shocked that I was asked if I'm an advocate or not, if I was born here or not. The only thing I wasn't asked is if I'm a woman or a man, and to prove it. My colleagues were made to look like criminals, the ones who are signed. They are respected in their profession. One, a director in a very respected law firm who does these affidavits every day or most of the days of his lives. One, a chartered accountant who does this some of the time. And integrity is important in their professions. And I'm a little bit saddened their names were wrongfully and unnecessarily maligned. But nonetheless, I am an advocate of the Supreme Court of South Africa. It was irrelevant that I was asked, because whoever needed to know that should have just checked the records of the LPC. They would have found my name and my number. But it was irrelevant because the person wanted that information for the purposes of reporting me, and that could have been done after this process. It was not relevant to the evidence that you as a committee need to know in order to make a finding on whether or not the client of Advocate Mpofu, my successor, Advocate Busisiwe Mkhwebane, is guilty of the things she's accused of. And thank you for the privilege. Good luck to everyone who's involved. And thank you for what you're doing to make our country work and work for everyone. Bless you.
Thank you. Thank you very much, Advocate Thuli Madonsela.
Chairperson, I'm raising a point of order.
I am on the platform.
Sorry.
I've not noted you to speak. Switch off that mic, please.
Yeah, but how else?
Switch off that mic, Advocate Mpofu.
I'm catching your attention.
Switch off that mic. I've got your attention.
So
Switch
why
off
are
the
you
mic.
shouting?
Switch off the mic,
Thank
Advocate Mpofu. I was saying, Advocate Madonsela, on behalf of this committee, as a chairperson of this committee, we want to deeply thank you for availing yourself before the 1st of March, before yesterday, and during up until today. You have even given us an extra time. We needed to release you by midday today. You allowed us to get into your time in that, and I'm grateful for that on behalf of this committee. We thank you for what you brought here as your testimony. As the committee, we are going to deliberate on all of these issues, including what you shared with us. And we hope and trust that that testimony will be of great use for the work that we have been mandated to do, which deals with issues of incompetence and misconduct, the fitness to hold office of Advocate Busiswe Mkhwebane, so that by the time we report to the National Assembly, we're able to say, here are the findings, here are the recommendations. So we thank you for your contribution, and beyond what you've just placed in this inquiry, we thank you for what you would have done as a former public protector, and we wish you well in your current and future endeavors that you're doing as part of your contribution to this country. Thank you very much. And on that note, as I've indicated, we would have reached the end of our interaction with you. You are now officially excused, Advocate Madonsela. Thank you very much. I now turn to you, Advocate Mpofu. You wanted my attention.
Yes, thank you, Chairperson. You see, you must avoid turning this committee into a complete circus. I made an objection while Advocate Madonsela is here. You shouted at me for no reason because you want to release her before I speak. I wanted to say, Chairperson, you should not allow things like what you've just done now. The witness, there's a reason why why Parliament designed the inquiry the way it did.
What is your point you want to raise?
Because
I'm now closing the session. What's the point? Because I'm going to assist you.
Yeah.
Just let me help you. Let me help you.
I don't know what I'm going to
Then
say.
conclude.
No,
Please
I don't
conclude.
need your help. Yeah.
Then
Okay.
conclude.
All right. The witness, what that witness said in the end about her being an advocate must be completely struck off anything to do with this committee, because a witness cannot surreptitiously add evidence at the end when she refused to answer the question which was put to her in evidence here under oath. And the reason, this is a very important issue, Chairperson. If you allow that kind of deceit and disingenuity to pervade this process, then you are littering it and poisoning it. The witness, I gave her 4 or 5 chances to answer the question. She chooses when you're about, and then you ignore me so that you can release her, and then she gives evidence at the end. It's not allowed, Chair. The reason why I had
You've made your point.
Yes, point. Thank you,
You've made your point.
No, let me just say this.
Thank you,
please,
Advocate
Chair. No,
you have made your point.
Chairperson, let me just finish, please. I promise you I won't be long.
Finish,
I won't be long, yeah. The reason, Chairperson, why I put the question to the witness, and when she refused to answer, in fairness to her, I did not pursue the matter, is because we had information at our disposal that she was not an admitted advocate when she started as public protector, and she subsequently was enrolled. But because she refused to answer the question, I did not put the issue, that proposition to her. And if she had not refused, I would have put it to her, and in fairness, she would have cleared the air or whatever the situation is. It's a very serious allegation, and so to allow it to be addressed like that is really objectionable.
Thank you,
but that's fine.
Let me just make this point, because there's no basis for what you're doing. First, you started yesterday at 10:43, and I would have given you up until 3:30 to 4. You finish at 1 minute after 6. You had that time with yourself for everything that you wanted to do. Today, you would have been given time from 11:38 as pickup questions. Pick up anything that would not have been concluded. And I had to stop you from doing that. And I must just say that it was now the chair addressing the witness, because the witness yesterday never denied or confirmed issues of advocate. Never. And for you to say that she refused to answer that question, that's something else. But
What was the answer?
Besides that, I didn't let you to speak. Please stop doing what you're doing. And in any case, I have already addressed Advocate Madonsela and asked and recused you officially that you have done what you came here to do. On behalf of this committee, we're happy with that contributions and we're going to look into those issues as part of our deliberations. Thank you very much. You are excused.
Thank you.
Thank you. Honorable members, that's the end of our inquiry today, which was meant to be up until 12. You have already received the correspondence that, and we can take a break for that. It's almost, or we can go for lunch and come back for 30 or so minutes and deal with some of the in-house issues that we need to deal with whilst we're here and not convene another meeting. Let me just hear from you which of those you prefer.
Chair, Chair, please, just 1 second.
Honorable Ngosi and then Honorable Sukas and Mylan.
Chair, may I propose that we proceed for that 30 minutes or 15 or so and finish so that those that want to attend the house can do so at 2.
Okay. Honorable Sukas, I know you had a different view. You raise it.
It was my view, Chair, if we could break for 30 minutes and then resume.
Okay.
Withdraw.
Honorable Mylam and Honorable Heron and Suela. It's a quick thing. Don't make it complicated. What is that? I don't know that sign language. Come again? You covered by which of the two? Oh, I didn't know about that. Have you withdrawn, Honorable Ngos? Oh, thank you. Honorable Heron?
Chair, I wanted to support Honorable Nkosi and say, let's proceed and conclude now.
I'm told he's already withdrawn.
Then I'm tabling it as a new proposal that we don't break 30 minutes and get.
Thank you. Honorable Suela.
30 minutes more.
I'm supporting Honorable Heron that we proceed 15 minutes and then we close. Thank you.
But despite that, we do need a break. Yes. Even if it's 15 minutes, if it's not the 30 minutes. Colleagues who have been here. So I'm going to have to overrule that and just make a determination that can accommodate all of us. Before we do that, Advocate Prof.
No, Chair, sorry, mine is a small one. It's to do with your meeting. I wanted to just to confirm that you got the second correspondence that came this morning, which was rushed so that it should form part of your, in other words, instead of bringing it later.
Thank you. We have
thanks.
all of those. Thank you. Honorable members, I'm going to ask for your indulgence, Honorable Heron, so we can take about 30 minutes and come back. That it will be before the 2 o'clock house sitting. Thank you. We adjourn and back at 1:30. Yes.
Recording stopped.
welcome back to this committee session. As we indicated before lunch, we now about to start. We indicated we'll start about 30:30. I think small delays in the lunch, but I think we should now be good to go. Let me just check if we're connected and if members can hear us. Honorable Malema, can you hear me now?
Yes, Chair, I'm on board.
Thank you. Thank you very much. Good afternoon again to all of you honorable members, the members of the media, the support staff, as well as the members of the public. After completing the inquiry with the last witness that we had today, I had indicated that there are few in-house issues that we quickly need to attend to, mainly in two categories. There's some urgent correspondence we need to attend to and respond to. And secondly, we can conclude the meeting with the in-house adoption of minutes, since we are here. Honorable members would know that in terms of our revised program, the next form of activities is supposed to start from next week on the 15th of March, when we would have the public protector, Advocate Mkhwebane, giving her testimony. And the program indicates up until when that will happen, which is the 31st of March. There are a few issues before that we need to kind of iron out, which will be part of this correspondence that we will attend to. There's correspondence from the PP through their attorneys, but would also share with you the letter that were copied on by the PPSA on their financial situation and how that financial situation will impact on the inquiry. So just want to quickly, I'll ask the committee secretary to just lay down those correspondence that would have been sent to you, and then get a brief input on those, have a discussion on them, and then we'll conclude on that aspect, and then we do the normal business of the minutes. Are there any apologies you've received for this part or session of our meeting, Mr. Ngoma?
Thank you, Chair. Thank you, Chair. Except that Mr. Manedi will be joining us now. There's no apology for this session. Thank you, Chair.
Thank you. Thank you very much. Can you then just start running through what correspondence we have received, and then I will invite Ms. Ibrahim thereafter.
Thank you. Thank you very much, Chairperson. There's a number of correspondence that I shared with members during the course of proceedings today. The first one, Chair, that I would like to talk to is an affidavit that I received from Advocate J. Govender from the Inspector General of Intelligence Office. She works there as a legal advisor. I have shared the affidavit with members. I received it after I had requested some information from her as the secretary of this committee, and she then provided that written affidavit. The next one, Chair, is the correspondence that I received on the 5th from Sianejo, which is a response to the letter that you wrote to them on the 1st of March. That is after we had taken a number of decisions last week, and then we communicated with them, which led to the committee having Advocate Madonsela appearing over the past 2 days. I'm not going to go through the letter, Chair. Members do have it in their possession. The next letter, Chair, I received it during the course of this morning's proceedings, which is dated today, the 7th of March, also from Sianejo. And that letter, Chair, is it talks on the witnesses that the public protector still intends to call to appear before the committee. As I've indicated, that that letter is also with the members, Chairperson, and I hope that all members have received it through their emails. The last one, Chairperson, being a letter wherein I was copied into, it's a letter to Advocate Mkhwebana from the Chief Executive Officer, the PPSA. I was copied into this letter, and I felt that it is important that I table it to the committee as it talks to a matter that could have impact on the work of the committee. Chair, the letter is on the discontinuation of legal services to Advocate Mkhwebana that are being provided by the PPSA in relation to the work of the committee. As I've said, Chair, I'm not going to go through it. Members have it, but I'll, Chair, before I switch off, if Ms. Ibrahim has anything to add or would like to provide more detail on the correspondence, then I'll leave that to her. Thank you very much.
Thank you, Mr. Ngoma. Ms. Ibrahim.
Thank you, Chairperson. Chair, the correspondence does necessitate that the committee makes certain decisions and deal with certain issues. So I'll just go into a little bit more detail than what Mr. Ngoma did. And there are two letters which primarily form the subject matter before the committee this afternoon. Chair, the first letter, which is dated 5th of March, in which members do have a copy in their possession, relates to the submission of the PP's statement and her appearance before the committee. As things currently stand on the program, the PP is due to commence her evidence on 15th of March, which I think is next week, Wednesday. And it was agreed initially that she would submit her statement by today, the 7th of March, but that date was subsequently pushed out following the offer made to the PP last week that should she wish to lead Advocate Madonsela, then that opportunity would be provided to them. And in that letter, Chair, it was then said, if they avail that opportunity, we will push out the statement to 9 March. But should she wish to submit in 2 parts, she may do so on 9 March and 14th March to give them enough time to prepare. That offer to put questions to Prof. Madonsela, as we know, was accepted at the meeting last week, Thursday. At the conclusion of the meeting, just before they left, Advocate Mpofu indicated that they will accept the offer. That was done orally. So our understanding was that the offer of the statement, the submission thereof being split into 2 parts, was accepted. However, Chair, we now in possession of this letter of the 5th, which is asking for an extension. And what the letter is requesting is that we push the date for submission of the statement to the 20th of March, and then the appearance of the PP to the 27th of March. And then in terms of dates, Chair, just to remind the committee that we are sitting in the Western Cape High Court on the 13th of March for the final day of hearings in the review matter. And then there is a public holiday on the 21st of March, and I know Advocate Mpofu is not available on the 22nd. So those dates were purposely left open in the schedule. Chair, the directives do not speak to the procedure for the PP submitting a statement. The PP is not compelled to submit a statement. Members may recall that prior to us starting the hearing portion of this process, she was provided an Audi opportunity, if she so wished, to respond to the charges. That opportunity was not availed, but of course, should the PP want to submit a statement, she may do so. What the committee must now determine, Chair, is whether it's reasonable to expect that that statement be submitted by 9th of March, which is 2 days from now, given that we concluded with Prof. Madonsela today, because it's on that basis that the extension was sought, that everything else in the schedule had been pushed out, and therefore this should too. Then the letter of the 5th of March, Chair, also spoke about the possibility of calling 3 additional witnesses, and that was Mr. Musi Mayamani, Mr. Mayema, and Mr. Linda, who's the messenger, whose affidavit the committee has in its possession from the PPSA. That request, Chair, must be read in tandem with the letter received today, which speaks in more detail to that particular request. Mr. Musi Mayamani is being sought in relation to CR17 and Frieda. Mr. Mayema, who works for the NPA in relation to the rogue unit. And then the letter of today indicates that they no longer seek to call Mr. Linda. So there's not much information in terms of why Mr. Mayema and Mr. Mayamani are now being sought. Mr. Mayamani did indeed appear on the Public Protector's first provisional witness list, but not on the final witness list. But according to the letter, he has indicated his willingness to assist, and what the committee sought to advise is the date on which the committee intends calling them so that they can then prepare the statement. So the committee is obviously not in possession of affidavits from these 2 witnesses to now determine already whether it wishes to call them to testify, or if the committee may then simply accept the evidence as contained in the affidavits. Obviously, we haven't seen the affidavits in order to determine that. So the scheduling, Chair, is only in respect of Mr. Mayamani, because as far as Mr. Mayema is concerned, they've indicated that it's subject to them obtaining permission in terms of the NPA Act. Chair, the letter of today doesn't speak to the question of whether they wish for Mr. Mayamani to testify if the committee so decides that he should testify before the PP commences her testimony. So there's no clear request in that regard. If so, one would have to then factor in the time for drafting and preparation of the statement, submission of the statement, and then push all of the days out accordingly. However, Chair, there's also no requirement in terms of the directives that the PP needs to be the last person that appears before the committee. So nothing would prevent the committee from scheduling these witnesses at another time if it so wishes. So the committee must now determine, Chair, how to deal on the one hand with the request for Mr. Mayamani for a date to be scheduled, and whether the committee would rather want to wait for the tendering of a statement in that regard and then determine the way forward, but also on how to deal with the request of the Public Protector that she be allowed to submit her statement at a later date, being 20th of March, and then pushing out her appearance to the 27th of March. So that is the guidance that we seek from the committee so that we can convey it to the PP's team. Thank you, Chair.
Thank you, Ms. Ibrahim and Mr. Ngoma, for the tabling of that correspondence and the explanation accompanying that. Those are the quite a few decision requiring issues that we need to attend to. I'm not going to prescribe or restrict members, but I will be looking out for when members contribute to indicate in terms of those areas what their interventions are and suggestions on those areas that have been highlighted by Ms. Ibrahim. The first of those that we know that the program starts next week on the 15th with Advocate Mkwebane. There's an issue about the extension on the statement, if so required, that it was due for the 9th. Initially it was due for today, But once we brought Advocate Madonsela yesterday and today, we could not reasonably expect them to deliver on that. Hence, it was pushed for the 9th. And the issue here now with us is it still kind of reasonable to expect that from the 9th, or should we extend that, understanding that we're starting on the 15th? Just summarizing the issues for you colleagues. Also taking into account that there's not been clarity in their letter as to, so there's also issue of witnesses, new witnesses that are being requested to appear by the PP team, Mr. Mayema and Mr. Maimani, as well as I think there's a bit of information about what's happening on the 13th, which means if you were to extend anything, it would be seen unfair, the fact that Advocate Mpofu will be in court on the 13th, or the PP team. So those are some of the issues, colleagues, that we just need to attend to in your contributions and deliberations. Tembingosi has indicated, you'll read that at your own time, the affidavit of a Advocate J. Govender, but also you also need to take into account in your contributions the letter that states that is directed to the PP from the PPSA, the CEO of the PPSA, indicating that they can only fund this inquiry up until the 31st of March. 31st of March is supposed to be our last day to interact with the witnesses, because April is supposed to be a report writing process. That anything beyond the 31st of March, that office says it doesn't have the funds to continue. I now invite contributions from all members to hear what your take is on these issues. Let me invite a show of hands of those that are interested to interact. Honorable Mailam will start from the virtual. Honorable Bekizwe Ngosi will follow. There doesn't seem to be any other members interested to interact with this at this stage. I'm watching. Let us allow Honorable Mailam.
Thank you, Chairperson.
Over to you, Honorable Mailam.
Thank you very much, Chairperson. Chair, I have a concern, and that is that the witness list seems to be never ending. So we just seem to be about to hear from Advocate Mkhwebane, and then they introduce new witnesses. And we just seem to be about to hear from Advocate Mkhwebane, and they introduce new witnesses. And I think we need to put a stop to this. I think we need to say, okay, we've given you an opportunity. We've called the witnesses that you asked us to subpoena. We've done everything that you asked us to do. And we now, or the ones that we think are relevant of the witnesses that you asked us to subpoena. And we now have to draw a line in the sand because we have to conclude this inquiry. I think that we need to push for Advocate Mkhwebane's statement as quickly as possible. I do think that we do need to grant a little bit of leeway, given that there's the review application on or early next week. But I don't think we should allow it to extend as far as the 20th. I think that we should look at probably, I'm not sure what the dates are, but by the end of next week, we should have the statement in hand, and 7 days thereafter, we should go to a hearing with her, where we can have an opportunity to interact with her, because otherwise we run into April and we're still sitting waiting for witnesses in April. That's my opinion, Chairperson, and I hope that it will be considered. Thank you.
Thank you, Honorable Mailam. All those points taken and noted. Honorable Nkosi.
Thank you, Chairperson, and thanks for the Secretariat for providing us with the correspondence. I just want to start with the PPA letter that is copied to us. I've just gone through it, and it's clear, Chair, that in terms of this correspondence from the PPSA, I can't remember where the paragraph is. I think it's paragraph 12, where it says, in the circumstances, I wish to advise you that the PPSA will not be able to extend the funding, blah, 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 beyond the current financial year ending 31st of March. Incidentally, that corresponds with our own program. Chairperson, I think the constraint we then face is that whatever we do beyond, if we are to extend our program beyond that in these engagements, except for the writing of the report, the PPSA will not have funding. And it's clear that we also must act in the interest of guarding the taxpayer and what they are paying for. So, Chair, let me, after noting that, I would propose that one, in as far as the following statements, we take them as submitted. One, the statement that was submitted to us of Advocate Govender. We've done that before, there's precedent, so this must be submitted and we'll read it. It will be read into the record. The issue of additional witnesses and the statement of Mr. Maimane, who is prepared to write, that at the time that it is written and the affidavit is availed, it also be treated the same as submitted and as read into the record. And depending, as we have said again, on relevance. With Mr. Maema, we don't have, it's Maema, yeah. We don't have anything, we don't know when he's going to submit, because that pends a decision of the National Prosecuting Authority. So we can't comment on this one. In the event, Chair, that Mr. Maimane submitted his affidavit, we will then determine on the basis of relevance whether we will hear him, and if we do, when. My proposal at this stage is that the statement be submitted and be taken as read. If the committee determines that it is relevant, we can hear it anytime. We shouldn't prescribe before the appearance or non-appearance of the PP. Chair, I want to address the issue of next week. I hear what Honorable Mailan is saying, and I agree with him that we should give the PP enough time to prepare the statement. I think we have done so. We've done so, I think, close to about twice now. My approach would be that, one, the statement should still be submitted, that it doesn't determine the appearance, that the statement is done and is submitted, but that we proceed with the PP appearance on the 15th, because there's nothing in the rules that says she cannot appear before she submits a statement. Yeah, so that will be my proposal, Chairperson, that we proceed with the PP on the 15th. The statement will be submitted, that she appears here, and yeah, whatever adjournment will be given on the basis of commitments outside of like you have indicated if the advocate is not available, yes, we can consider that. But really that we begin with this process at that stage. And Chair, this is simply informed by the fact that we have ourselves constraints of time, and we should not subject, in my view, the PPSA to a process as Parliament to engage in unlawful or irregular expenditure beyond their budget. Otherwise, we will take the blame, or Parliament will take the blame. So, Chair, that would be my proposal. I'm not sure if you will be able to summarize it, but I think it should stand as such.
Thank you, Honorable Nkosi. I definitely will be able to. I'm taking notes. Thank you for your contribution. I'm looking for other members that want to make a contribution in addition to Honorable Mailam and Honorable Nkosi. Honorable Sukas. Would be followed by Honorable Siwela. In that order for now, thank you. Honorable Sukas. And I know what you're thinking. You are not going to waiver anything.
I'm going to say, Chair, that I think what is most important that we have highlighted before, we need the public protector to speak to this Parliament. And as such, I would say, Chair, that we provide the public protector with the leeway in terms of the statement, then to us before her testimony, possibly on the 14th. But for the date of the appearance of the public protector before this House to not be postponed. And that what was proposed by Honorable Nkosi in terms of the other witnesses that the public protector wishes for this committee to hear, that that be considered in terms of written statements for consideration, but that be done with the understanding that it is the public protector now that must be before this Parliament. Thank you.
Thank you, Honorable Sukas. Noted, Honorable Siwela.
Thank you, Chairperson. Chair, I think I want to concur with the colleagues that we accept those statements, but let's resume with the appearance by the protector on the 15th, because we can't really ignore what we have been advised on the issues of funds. So I don't want to waste time, just to support that. Let's proceed. We have indicated, Chair, that not necessarily the issue of funds, but we have got other commitments as members in Parliament. So this process, I think it's taking far too long. Thank you, Chair.
Thank you, Honorable Siwela, for your contribution. Honorable Maneli.
No.
Honorable Maneli. Yes.
Thanks, Chair. I'm no longer on the virtual. I'm here.
Okay. We'll see you when you got in. So
okay, thank you.
Don't know what's that.
No, thank you, Chair. I also want to join the other members who are saying we should be able to proceed. I think with the motivation, Chair, that has been given, except to add that we are also asked to look at the fairness so that it's not just about time and cost, they are just part of it. But in fairness, the person to appear and account to this inquiry is the public protector, who has been coming throughout, listening to everybody else, and except herself given an opportunity to speak for herself. And I think for me, that fairness, it's out really creating the opportunity for her to speak for herself, and that you do not prolong the processes to a point that she herself would feel that there's probably no value that the committee places on her being given the opportunity to speak for herself. That's one point, Chair. The other point, Chair, relates to the time that gets given, and that's why I'm saying Honorable Nkosi has covered me on this point. I'm only just putting a finger that throughout the process, you've always communicated, as we deal with the other witnesses, the timelines for submission. And this committee has agreed, even at the time there was to be a withdrawal of the witness that we have engaged with, that still consider giving the time, and initially was the 7th, Chair, and therefore extended to the 9th to allow that the 2 days should not be lost in the process for their preparation, so that members also have an opportunity of going through the statement, if there's any statement. And I'm saying if there's any, based on what has been raised already, because probably the public protector may also elect not to. We've already got witnesses that came before the committee that opted not to, but ready to come before the committee and clarify matters. And I'm saying at least if they elect to go that route, there was a timeline that was given, and there's not been objections to that timeline over a period of time, Chair. So I'm just saying, over and above all the other factors, I think it's only fair that we are able to proceed, and let's hear what else comes afterwards. And as I said, with regard to statements that Honorable Nkosi referred to, I agree that we accept, just like we would have wanted to accept a statement even of this previous witness. But you are flexible, Chair, to listen to argument. So I'm just saying, so far, I think that fairness issue still is something the committee values. Thank you,
Chair. Thank you, Honorable Maneli. Now recognize Honorable Nodada.
Thanks, Chair. Chair, I don't want to belabor the point, but just to say that I do support the views echoed by Honorable Milam and other members, that we do stick to the timelines of giving the public protector the opportunity to take the stand, as they had indicated in the beginning, even though they did out of protest, that is the intention, because I'm sure that whatever has been said and put to her should want to clarify the nation and all those that seek answers based on the determination that we need to make as a committee. This should be despite the fact that we may get witnesses after the case, but we should stick to that particular timeline. And we've got another responsibility as this House of ensuring that a Chapter 9 institution doesn't find itself in a position in which will be questionable by the very same people that are sitting in this room, if they go beyond the timelines of assisting Advocate Mkhwebane and find themselves in an irregular expenditure situation. But more importantly, what Honorable Maneli raises is the issue of giving her the fair chance to respond to every single thing that has been put to her on this committee. And we will deal with witnesses that have then been requested to submit statements or make oral submissions to this committee within that particular timeline, before or after. But that particular date set for her to respond to us must be stuck to. Thanks, Chair.
Thank you, Honorable Nodada. I'm going to check first so that I don't summarize and close other members out. Are there any other members who still wants to make a contribution to these issues that have been tabled so that they are not closed out?
We are covered, Chair.
You have not been recognized. You must raise your hand. And then uthethe after. Thank you, Honorable Ngola. No other member. So that I summarize with everybody in. That being the case, honorable members, maybe just one issue before I summarize as a way of clarity. Honorable Sukas was very specific in her proposal that we grant the extension to the PP from the 9th to the 14th. So I don't want us to have 2 dates. Remember, we granted the 9th from last week because of the 2 days of yesterday and today. And so her proposal is that give her the weekend as well. And therefore, taking into account that Advocate Mpofu will be in court on the 13th, let's expect a statement, if any, very important point, on the 14th. Do members agree to that firm proposal? Because there's only one member who made that proposal.
On the record, agree.
Honorable Ngosi supports, so that's we'll go with that. So basically, honorable members, what we're saying, members are of the firm view that we have a standing program. That program, from the very onset, we said it's a living document. That there will always be issues where you are forced to review and amend it. But still within that context, that the time that we have is not open-ended. It's not elastic. There's a time frame that we operate within. I've just made the point, secondly, that we, in relation to the request of the PP in the letter of the 5th, where she has asked that the statement be submitted on the 20th of March and that the PP give testimony on the 27th, this committee is of a different view and therefore says for issues of fairness, we're going to grant it's a further granting of the extension from the 9th to the 14th for the statement to be submitted if there's any statement. And secondly, as opposed to the 27 proposed, this committee is of the firm view that our program that starts on the 15th should stand, and that we expect the PP to give testimony from the 15th until the 31st as originally planned. So that we go with it as it is. I take it that members are noting the statement submitted by Advocate Govender, and you would read that at your own time. The next firm proposals, which there's no objection to, is that even firstly that statement of Advocate Govender, that it must be taken as submitted and read into the record. Okay, that's firm, but also the additional 2 witnesses that have been mentioned, actually 1 witness, Mr. Maimane, that if there's a statement, also that statement is read, submitted and read into the record. And at that point, when the statement is submitted, we'll look into the relevance of what is submitted, and we'll decide then whether, based on that relevance, we would require to do oral hearing, or we'll take it as a statement. And at this point, it's difficult to speak about Mr. Maema because he's still not a witness. There are still efforts to source him out from the NPA. And that's not a space that both the PP and ourselves are in control of. Okay. And I think a strong point is made that the PP appearance on the 15th should not directly be linked to the state issue of the statement, because it doesn't determine that. But a caution to this committee and members of parliament on behalf of the National Assembly, having received the letter from the PPSA, the CEO, about them having run out of funding by the 31st of March, that this committee is an extension of the NA, which plays an oversight role to the PPSA, cannot ignore those facts and cannot force that institution to operate unlawfully. And then we become the same people who are going to question them why they spent money they did not have. I think I'm getting that very clear, that we should avoid forcing the PPSA into unlawful activities, that the program should remain intact, and that we allow for the possibility that witnesses might even come afterward, listen to the PP, because there might be issues that arise out of that. So including the issue of Mr. Maimane and other witnesses. By way of summary, that's what I'm hearing from all of you colleagues. Is there any objection to that summary? Based on your contributions? No objection. Thank you, honorable members. Therefore, that's our summary of that discussion on all of those issues that were raised. We're now going to step off that and proceed and ask Mr. Ngoma to quickly take us through. This is now the normal process of us not packing minutes. Take us through the set of minutes that we have as a last point, so that we can conclude our meeting and join the National Assembly sitting. Mr. Ngoma.
Thank you, Chairperson. Yes, I would love to get members to the House as soon as possible, Chair. Chairperson, we start with the set of, just a sec. Yeah, we start with the minutes of the 21st of February. Wherein we adopted the minutes, and then we had Mr. Matabu appearing before the committee. So the 21st of February, Chair, before you.
So those are the minutes. So we're going to go through page by page for corrections, colleagues. If you're able to have a look, and we're still running it through for you to further make those corrections if there are any. No corrections. Do I have a mover for the adoption of the minutes?
I move, Chair.
Honorable Nkosi moves. Do you have any seconder?
I second, Chair.
Honorable Maneli at M46 seconds.
Thank you, Chairperson. The next set of minutes, the minutes of the 22nd of February. Chair, is the minutes of the 22nd of February.
Please mute Honorable Sewell. Please mute Honorable Sewell. Go ahead, Mr. Ngoma.
Yes, thank you, Chairperson. This the minutes of the 22nd of February. Members would remember that's the day we also had in committee session, wherein we discussed the matter of Mr. Mataboge's appearance and the SMS of Mr. Mojaki and yeah. Chair.
Yes, any corrections, members? As we go through that, page 3, the last page. Do I have a mover for the minutes?
Chair.
Honorable Mahlaule.
I want to move for the minutes, but Mr. The scrolling was very fast. I did not see my name on the register.
Okay, okay.
I attended.
Let me do it. Thank you. Thank you for pointing that out. Let's go back because that's an important part also. Thank you for pointing that out, Honorable Mahlaule. Because Stemogos don't, just go page by page, and then I will indicate when you go to the next page. Hey, we'll go to the first page on top. Now we'll start so that we know what date that is. Thank you. That's the date, the 22nd of February. Members present, go so slowly. No. So I think the problem here is the person who's running it. He is struggling to.
There's just too much on my screen.
Unless you want to hide Honorable Mahlaule, I can see he's there.
His name is there.
Thank you. Proceed. Go. Sukas had raised his name, is there. His name. Honorable Maut there. Apologies. That's page 2. You go to page 3. Thank you. Agenda at 11:45. Do I have a mover for the adoption of the minutes, members? Honorable Sukas.
I move for the adoption, Chair.
Suele seconds.
Honorable Sukas moves and Honorable Suele seconds. Minutes duly adopted. We'll go to the next set of minutes. I get only the sharpshooters more. Please mute Honorable Zuel.
Chairperson, the next set of minutes is Thursday, the 23rd of February, and Chair Mr. Mahlaule was there. So is Ms. Sokers and Mr. Heron and Ms. Den.
For those corrections, go page by page. That's page 2. That's page 3, which is also the last page. Thank you. Do I have a mover for the minutes?
Chair, I move for the adoption of the minutes.
Honorable Sukas moves for the adoption of the minutes.
I second, Chair.
Honorable Mahlaule seconds. Minutes duly adopted. Can we move to the next set, please?
So just now, Chair. Chairperson, the next set of minutes are for Monday, the 27th of February. There's so much here on the screen. I'm just trying to quickly get into them. Just need to close. My screen is packed. Thank you, Chair and members, for your patience. On the screen are the minutes of Monday, the 27th. 27th, Chair, is a pay date for the municipal workers in Cape Town. So minutes of the 27th of February. Even there, Mr. Manel was in attendance, Mr. Ngola, and now the Deputy Minister, Ms. Chabalala, was also in attendance. So is Ms. S. Jafta.
Okay, let's move. That's page 2.
These ones are very short. Chair. Was an appearance of Ms. Mvuyana.
Okay, thank you. There being no corrections, do I have a mover for the minutes?
I move, Chairperson.
Honorable Ngosi moves for the adoption of the minutes. Any seconder? Honorable,
I second, Chair.
Honorable Maneli seconds. Minutes are duly adopted. We move to the next set of minutes.
Chairperson, the next set of minutes are for Tuesday, the 28th of February, which was the last day of February. Unfortunately, our committee assistant could not have a birthday in February. He was born on the 29th. So this year he could not have a birthday, Chair. Yes, the gentleman right there, the back, Chair.
It's a very good way of saving costs.
Chair, maybe I should
corrections.
remove Mr. Mahlaule's name here, Chair, because he rejoined later during the day.
Okay.
I had marked him as apologized, but you'll see that his name appears just before the name of Ms. Chabalala on the attendance register. That's the reason why it's there at the bottom, because he joined us in the afternoon.
Thank you.
Chairperson here also had Ms. Mvuyana appearing before the committee, very short minutes. We also discussed correspondence. There were matters before us which related to committee matters.
Okay, let's go to the last page, which is page 4. That's the end of the minutes.
Yes.
Do I have a mover for the adoption of the minutes, colleagues? Those that were present. Honorable Ngosi moves. Any seconder?
I second, so in a second.
Honorable Suele seconds. Minutes duly adopted. Can we move to the next set?
Thank you, Chair. The next minutes, Chair, which is the last set of minutes that we'll adopt for now, is for Wednesday, the 1st of March, which happened on that day. It was my daughter's birthday. She turned 18. Chairperson, the minutes of the 18th, Chair. Sorry, of the 1st, wherein Prof. Madonsela appeared before the committee. Yeah, Chair, just to make it clear that you even clarified here that the meeting of the 28th was not closed. That's when you had asked the evidence leaders and the PP legal team to excuse us, and later was said that the meeting, people were excluded. The meetings of this committee, Chairperson, are public meetings, open to the public, and at no cost except under certain extreme circumstances that would have in committee sessions. So that's the minutes, Chair, of the 1st of March.
Thank you. Any corrections? None. Do I have a mover for the adoption of the minutes?
Chair, I move.
Honorable Bekizwe Ngosi moves. Do I have a seconder?
Seconded, Chair.
Honorable Ngola seconds. Minutes are therefore duly adopted. Thank you. That was the last set of minutes that we're looking at, and the time now is 2:30, 32 minutes after 2, which brings us to the end of our committee session meeting. and allows us to go and participate in the National Assembly matter activities. On that score, honorable members, we will see you next week. As planned, if there are any issues, you will be notified. Thank you very much. The meeting is adjourned.